Any mention?
May it please, Lordship.
Yes.
Lordship, I beg to mention item number 8, 9 and 10, Lordship. Lordship, these are connected matters, Lordship.
Item number 8.
8, 9 and 10, Lordship. Connected matters, Lordship.
Yes.
Lordship, I am praying for 1 week's time, Lordship.
Why? What for?
Lordship, senior counsel has some difficulty today, Lordship, so kindly accommodate for 1 week, Lordship.
No objection, Your Lordship.
Okay. On the prayer made on behalf of the petitioner, list this matter after a week. 8, 9, 10.
Deeply obliged, Lordship.
I will please, Your Lordship.
Yes.
Your Lordship, I beg to mention item number 11, Your Lordship. Lordship, I beg to seek 1 week's time as I need more time to prepare, Your Lordship. Item number 11.
This is criminal appeal.
Yes, Your Lordship. 1 week's time, Your Lordship, because I need some more time to prepare, Your Lordship.
No objection. You will not have objection because of criminal appeal, but then anyway, 1 week on the request of the learned counsel for the petitioner. Yes.
Will you oblige, Your Lordship?
Yes, Mr. Devan.
May I beg to item number 6?
Yes.
There is
Yeah.
one universal convenient date of my.
That event after vacation, after puja vacation.
Is this case which was hard at some
Item 2. Today I'm ready for that. Yes. Item 2, ma'am.
this 6 after 2 weeks on the prayer made on behalf of the respondent.
After puja vacation.
2 weeks, we said 2 weeks. Or make it 3 weeks.
Ma'am.
3 weeks.
May I please, Your Lordship?
Yes.
I beg to mention item number 4, Your Lordship. Your Lordship, I'm praying for 2 weeks' time, Your Lordship.
Who is paying for the other side?
No objection, Your Lordship.
What is the matter about? Service matter?
No, Your Lordship, it's a compensation, Your Lordship,
Compensation for
for the
land. It's a 2019 matter. No interim order, nothing in this matter.
Your Lordship, this matter is being conducted by Mr. A.H. Karwanlang, Your Lordship, so I
He's not here.
know, Your Lordship. Mr. Shulai and Mr. Karwanlang, Your Lordship.
None of them are here.
Mr. Shulai is on legs, Your Lordship, in court number 3.
Okay, make it after 2 weeks on the request of the learned counsel for the petitioner. Yes.
Obliged, Your Lordship.
Yes, Your Lordship, I beg to mention item number 7, Your Lordship.
Item number 7.
Yes, Your Lordship.
So what remains then in the list? Yes.
I pray for 2 weeks' time, Your Lordship.
This is writ petition criminal against conviction in court martial.
Yes, BSF court.
What is the
7 is imprisonment with and dismissal from service.
is conviction under what section?
Hello?
Conviction under what section?
376.
376. Okay, 2 weeks on the request of the learned counsel. See, this is a 2022
Yes,
thing.
Your Lordship. After 2 weeks, Your Lordship.
See, this appeals in especially matters involving sexual offence. This requires to be disposed of first. Okay, sir, 2 weeks on the request of the appeal.
May I list item number 1?
Yes.
Lordship, I'm entering appearance for the respondent.
So what your prayer is?
I'm the respondent.
Your Lordship, let the matter come up after some time. Mr. Shulai is on legs.
So you'll be taken up this matter.
Yes, Your Lordship.
Second call. Ready? I'm ready.
Do you want this to be disposed of today or?
Your Lordship, Mr. Shulai will be arguing.
Okay, just call it at the end of the vote.
Obliged, Your Lordship.
Item number 3.
Yeah, Lordship. On the previous occasion, the petitioner has filed one additional affidavit, Lordship. I prayed for time to file that reply to that affidavit, Lordship. I'll just pray for only 1 week time, Lordship. It's ready, Lordship. I'm waiting for the signature, Lordship.
Who is for the petition?
That, sir, only 1 week, Lordship.
None appears for the petitioner. Mr. Sheikh, you want to
Respond.
appear for the response number 10?
10, Lordship.
Praise for grant of further time for allowing him to file.
Confused.
I reply to the additional affidavit filed with the petitioner. Prayer allowed. List after a week. Yes.
Item number 2.
Yes.
May I please, Your Lordship?
Item number 2 is
Lordship will remember on the last occasion, this matter was argued.
this is what then? No, the number 2 is this is thing. Wings and wind. See, what is the case of?
What happened to it? Yes, 2 to 6.
Careful. The court has forgotten everything.
Your Lordship will remember.
Have you? Is there any similar matter pending before division bench? Probably you came for some motion and all. I was a part of the division bench.
No, I cited.
That is not dependent of the.
No, this is not.
This
Not
the
different.
issue.
But
Issue is not the same whether the
Issue is-
Assam Rifles is a part of CPO or CPM or not. That is not. Is it not the case before division bench?
No, before the division bench, my lord, before the division bench, I have cited some judgments where it said that all CPOs are same. What happened in that? Yes, some judgment I have cited. Your Lordship
That
have
is all
cited.
right. That is all right. I am not talking about the citation. The query is with regard to the matter which is pending before the division bench. Whether that would have a bearing on this matter or.
My lord, to some extent it has got some bearing.
I think probably you are not there before division bench.
Mr. Devnath is there on the other side. Mr. Devnath is there. But here the issue, my lord, that 17%, because all the central paramilitary forces should be at par regarding their rank, status and pay scale. Based on that, in all the central paramilitary forces, 17% limited departmental examination for accelerate promotion have been provided. But in Assam Rifle, what happened? They are not conducting it. But now they are in 2016 onwards. They have conducting the limited departmental examination only for promotion from the rifleman GD or other trade to the grade of assistant commandant, but not for the Naib Subedar. Naib Subedar is equivalent to the post of sub inspector in other central paramilitary forces. Assam Rifle post of Naib Subedar is equivalent to the post of sub inspector in other central paramilitary forces. They say those notifications of ministry, because all are under the Ministry of Home Affairs, SSB, BSF, CRPF, CISF.
This is one of the issues, isn't it? Whether
Yes.
Assam Rifles is a part of central paramilitary force or not.
That is exactly they are saying, but what happened? They are conducting the limited departmental examination. Following a suggestion from the DGR, they are conducting for the post of assistant commandant, not for the post of Naib Subedar or sub inspector.
So you are not qualified for taking part.
No, they are not conducting it.
No. For assistant commandant, you are not.
No, I am not aspirant to for that post, because that is more rigorous.
You are not eligible to take part.
No, I am eligible, but this is a more rigorous examination than the examination conducted for the post of sub inspector or Naib Subedar.
So you do not like to opt for that.
No, I have not. So I made a representation that since all other central paramilitary forces are conducting, and it was there in the recruitment rule in all other central paramilitary force, 17% promotion is made for sub inspector.
What about the recruitment rule of the Assam Rifles?
Assam Rifle recruitment rules is silent. But, my lord, it is 17% is both for assistant commandant as well as for sub inspector. What happened? Without framing any rule of recruitment rule, following a suggestion of the DGR, Ministry of Home Affairs permitted DGR to hold the examination 17%. It is made 20% in Assam Rifle, 20% for assistant commandant.
So that means they are acting on a different sort of notification. Not on the.
On their suggestion. That
has been accepted by the Ministry of Home Affairs.
Home Affairs, but they have not made any proposal for the sub inspector. Not made. Lordship will kindly. I would like to draw your Lordship's attention in the writ petition. Lordship, page 12 of the writ petition. My prayer in the writ petition to provide opportunity to appear in the departmental examination at par with other central paramilitary forces for accelerated promotion to the cadre of sub inspector, equivalent Naib Subedar, equivalent to the sub inspector. Lordship, may kindly turn to page 12 of the writ petition.
Yes, and there.
Yes. Here your Lordship will find, this is also Ministry of Home Affairs letter, your Lordship.
Yes.
18 December 2017. The President is pleased to appoint the following personnel of Assam Rifle to the rank of Assistant Commandant by promotion through LDC, Limited Departmental Competitive Examination, in Assam Rifle on successful completion of their pre-commission training at OTA, Gaya, Bihar, in the pay matrix level so-and-so and other allowances are admissible under rules from time to time with effect on the forenoon of 9th December 2017, along with their seniority position and allotment AR number as per the marks obtained in the DPC and SCO, course 39, OTA, Gaya, Bihar. Here your Lordship will find all are riflemen. Yes. All are riflemen. Now, Lordship, how they are conducting this limited, Lordship will kindly take a note, limited, LDCE,
yes,
second line.
Yes.
Now, authority, who has given the authority? There is no recruitment rule in Assam Rifle for holding such examination. They are holding for not for 17%, for 20%, only to the cadre of, it is restricted only to the cadre of assistant commandant. Only to the. Now, authority, your Lordship, authority. Under what authority they are conducting this examination and how they are promoting, that is there in the authority, in the just after those names, my lord.
Yes. Yes. Down below the tabulation. Yes.
Yes, authority. Government of India, Ministry of Home Affairs, DAX, approved note sheet dated 23rd September 2016 and OTA Gaya letter number so and so commissioning dated 9th December 2017. So, they given a proposal and the note sheet was approved. And on the strength of this, they are holding the examination for assistant commandant, not for Naib Subedar, which is equivalent to the sub-inspector. Now, in their affidavit in opposition, Lordship will find, for a moment, that will, my lord, support my case. In their affidavit in opposition,
Yes.
Lordship, Annexure 5, your Lordship. Lordship, page 20, it is a type copy. Page 20 of the affidavit in opposition. Ministry of Home Affairs, letter dated 8 February 1996.
Yes.
Filling up of vacancies of officers in Assam Rifles. I am directed to invite a reference to your letter number so and so, 19195, letter number so and so, 19195, and the discussion on 9196 in the ministry with GSG, Ministry of Defence, DG, Assam Rifles, and additional military secretary, Army headquarters on the subject noted above, and to say that on the basis of the suggestions made in the said meeting, the competent authority has approved the following method with regard to filling up the vacancies of officers in Assam Rifles. 20% of the promotion quota vacancies of assistant commandant in Assam Rifles will be filled up through regimental promotion JCOs and NCOs through departmental examination. As in existence now. For this purpose, DG Assam Rifles will take action to send adequate number of officers for regimental courses required for this departmental examination. The unfilled vacancies in the 20% quota. Now it is in other paramilitary forces it is 17%. They raised it to 20%, and on a suggestion made by the DGR, my lord. For the cadre of officers of Assam Rifle will be filled up by deputation of additional army officers over and above the 80% quota already earmarked for them till the long-term officiating pattern for Assam Rifle is decided. So, my lord, they made a suggestion only to the extent of assistant commandant. Only to the extent of assistant commandant. They say they are governed by the set of recruitment rules of Assam Rifle. They cannot be compared with other central paramilitary forces. There is no recruitment rule for this 17 or 20% for Assam Rifle for assistant commandant. They made a suggestion that was approved in the note sheet, and on the strength of that, they are promoting the rifleman to the cadre of assistant commandant, to the cadre of assistant commandant. Lordship, in repetition, I have shown, Lordship, page 12.
Now, what is the effect of approval?
Approval that they are denying.
No, say supposing if it is effective.
No, they are
approved.
They cannot partly do it.
Approved by the concerned authority. Will it not have the effect of a notification?
But they are depriving us. They are depriving because your Lordship in other central paramilitary.
That 20% is only for LDC. Not for regular promotion and all.
No, we are asking for LDC. Our case is for LDC, your Lordship. Our case is for only LDC. Your Lordship, I will show in other recruitment rules of other central paramilitary forces. Lordship will find, the first Lordship will find the notification of the Government of India, Ministry of Home Affairs. That your Lordship will find page 15. Page 15.
One second. Page
15 of the writ petition.
Yes.
This is a letter of the Ministry of Home Affairs, Your Lordship. Ministry of Home Affairs, Government of India. Subject, relegation policy for Assistant Commandant, GD, LDC, and Sub-Inspector, GD, LDC, in the Central Armed Police Forces. SC, LDC, SC means Assistant Commandant, and SI, Sub-Inspector, LDC, are based on the scheme circulated by the MHA, but they are letter dated 21/8/2016, 4/2010. The duration of training is of 24 weeks, and at the end of said separate training, Assistant Commandant, Sub-Inspectors, GD, selected through limited departmental competitive examination, LDC, will be put through a test examination to be conducted at respective training institute academy. A trainee has to score the required percentage of marks in the subject as prescribed by the concerned CPFs to qualify the basic training. If a trainee fails in any of the subject in final, these are the terms and conditions, my lord. If someone fails, then he will not be eligible. He will be given a chance. All these things.
What you are trying to point out from this?
This both the examination for Assistant Commandant and Sub-Inspector through limited departmental examination by the same notification.
In the Central Armed Police Forces.
Forces.
Now, basically, that is what?
They say
that they are not a part of the Central Armed Police Forces.
That I will show, my lord. All are CPOs, and I will show the judgment also. I will show the judgment also. And one part of that, now on the suggestion of them, note sheet was approved. The 17%, 20%, they made it 20%. Unlike other 17%.
No, because they are not going by that 17%, so they are not question making. That is, they have said that they are regulated by some other this thing. They are not regulated by that notification, which says about 17%.
My lord,
That's what their case is.
on the other day, my lord, I will show the judgment.
No,
One
it's
to
okay.
one parity must be there.
I am not talking about anything. You see, this is not the view of the court. I am just saying the contention which has been raised by the other side.
No, my contention is that all the central paramilitary forces are working under the Ministry of Home Affairs. So all the one-to-one parity, I will show, my lord. One-to-one parity must be maintained. And you have given a suggestion, I have shown. You have given a suggestion, you have adopted 17%, 20%. You have adopted for a limited departmental competitive examination. Through limited departmental, you are promoting the rifleman, GD. You are promoting to the cadre of Assistant Commandant. But the Sub-Inspector here, because all these things has come from the Ministry of Home Affairs. There, one of the contention is that these were not circulated to Assam Rifle. These were not circulated to Assam Rifle. And my lord, I have on the last occasion, I have filed a compilation of the judgment. The compilation of the judgment I have filed.
There is judgment of this court also into
This court.
2013.
This court, my lord.
That finding will be binding on this court.
Yes, my lord. So I'll show from that, my lord. So my humble submission, all the CPOs, Central Paramilitary Forces, are working under the Ministry of Home Affairs, Government of India. So all the decisions, and it should be from the nation case of the Supreme Court, para 4, 6 and 24. Para 4, 6 and 24, I have also placed that judgment before your lordship. It should be at par. It should be at par.
Was it with regard to particular post, some particular post?
No,
not a
one to
general-
one parity. It says one to one parity. On the other day, my lord, I have also placed, your lordship will remember in the division bench while sitting, your lordship was also sitting. There are one to one parity. I'll place that judgment. today, my lord. I have told your lordship.
That is why, see, this court precisely asks you whether this will have a bearing. The matter pending before division bench will have a bearing on this matter or not. That is what.
My lord, if your lordship thinks so.
I do not think anything. It is up to your case. It is for you. It is you to say. If
Then
you
your
say it will
lordship-
not have, then we will proceed. There is no problem.
That matter is on 12th of this month.
It's up to you. It is up to you. It's up to you.
Then your lordship may take up that matter and thereafter it may be taken up.
Whatever way you think it proper.
My lord, thereafter it may be taken up.
This court is not advising you anything. But then
Then lordship may take up this matter after the division bench. On 12th it is fixed. This week. Because it has, one thing is that it is CPOs. This is, to some extent that has got a bearing, to some extent, that all the CPOs need to follow the same policy. Because all the CPOs are working under the Ministry of Home Affairs. All the CPOs. And they have given a suggestion that you give us the approval for holding limited departmental examination only for the cadre of Rifleman GD to Assistant Commandant, but not for the Sub-Inspector, as provided in the Ministry's circular. And those circulars were, my lord, this is of 2000, these circulars, your lordship, they say that it was addressed to CRPF, BSF, CISF, ITBP and SSB. Therefore, it has got nothing to do with the Assam Rifle. Assam Rifle has got a separate set of recruitment rules.
that is exactly
So my lord, if separate set of recruitment rules is there, why they have given a suggestion to the Ministry of Home Affairs? They have given a suggestion to hold us the limited departmental examination, permit us to hold a limited departmental examination.
that is a contradiction in their state.
That is a contradiction. Then my lord, let this.
If they said they are guided by separate service rule, then
All
everything
right.
has to be done strictly in accordance with it.
Yes, my lord.
Then this suggestion,
Yes. The suggestion you taken approval. What prompted you? You have got an own set of recruitment rules. What prompted you to give a suggestion and take approval and promoting the Rifleman GD to the cadre of, it is more higher, Sub-Inspector is a group B, my lord, and that is a group A post. So your lordship may take up even after this, after 12th, because there also the similar claim. Similar claim is made.
that is exactly.
A similar claim is made. Let it come after.
If that issue is required to be decided by this court,
Yes.
and if it is pending before the division, so it is
Let it
always
come.
better allow the division bench first to take
My
decide
lord.
the issue.
Let it be.
Yes, what do you say, Dr. Mojika?
My lord, in my humble submission, my lord, in our affidavit, we have annexed the policy document of the Ministry of Home Affairs specific to Assam Rifles, my lord, which says that 20% promotion through LCD to the rank
That is,
of.
you see, that is on
My
the
lord,
basis of
that
a
is-
proposal only.
Though we have filed an affidavit, my lord, they have not challenged that. So this order stands, my lord.
Should I challenge?
Can I just,
Let him.
I have to write to submit.
You can relax for time. Just please.
So without a challenge to that, my lord, and this is from 1996, my lord.
This court has no idea about service matters. See, basically. So it's a kind of learning for the court, you see.
So, my lord, let this division bench matter be over. Thereafter, your lordship may take up this. That will do. My lord. Because
Now, my lord, this specific policy for Assam Rifles, which only provides for 20% promotion by limited departmental competitive exams to the rank of assistant
A
commandant.
proposal, if it is approved by the ministry, it becomes a policy.
So, my lord, that policy exists, my lord, and we are following that for last almost 30 years now, my lord.
Almost?
Since 96, my lord.
It is in existence from 1990.
Now,
So for all LDC thing promotion, you are following that.
my lord, and we have given only to the rank of assistant commandant,
What about for Naib Subedar?
we have not
There is no
implemented.
LDC.
There is no
That is by normal.
promotion, my lord. Normal channel of promotion, and they are availing of the promotion.
That
Now the
20%,
difficulty.
One second, just it's okay. Please don't mind. See, this 20%, what you are saying that policy which is in existence.
My lord.
Now, is it a part of the rule?
It is by way of executive instructions, my lord.
no rule.
So will it not contradict whatever is
The affidavit.
provided in the rules? Will it be
Exactly.
contradiction?
Exactly.
My lord, that I'll try to
Let us take
ascertain.
both the stands. There is
That
a-
I'll try to ascertain, my lord. But here, my lord, what they are claiming on the basis of a July 2012 Ministry's order, my lord, which says that there should be 17% post reserved for this kind of LCD promotion, my lord, to the rank of sub-inspector and also to the rank of assistant.
And you say that is not applicable to you.
My lord, kindly turns to this page, my lord. It clearly says relegation policy for assistant commandant, GDLDC and sub-inspector GDLDC in the Central Armed Police Forces, CAPFs, my lord. And my lord, at the bottom.
Then what about the finding of our High Court in 2013?
My lord, that has no relevance. In fact, I'll place a very recent decision Mr. Chanda was the arguing counsel in that also. This honorable court turned down their more or less similar prayer, my lord.
That is what under challenge.
That is precisely.
That is what under challenge on the other day.
Now,
now very lordship is.
There appears to be, I do not know, subject to whatever you say, like you.
Well,
if you see that decision of 2013, that is why I think, yes, this is by this High Court only. And there is a categorical finding.
Well, that is only with regard to the pay scale, my lord. What should be the pay scale of different ranks in the Assam Rifles?
Have you have that judgment with you?
Yes, my lord. I don't have a copy right now, my lord, but I am aware about the judgment.
You are aware. See, come to paragraph 6. If you say that, then it seems to be quite specific so far as the issue is concerned.
My lord, that judgment is only with regard to pay parity of different ranks, my lord.
But then it has been held that Assam Rifles is a part of CPU, CPMF.
CPMF, but not CAPF, my lord.
It's not the same.
No, my lord.
Is one of the Assam Rifles is one of the Central Police Force.
Central Police Force is something different, my lord. My lord, if lordship kindly turns to my affidavit, my lord.
It's all right. Dr. Mojika,
because there was a lot of confusion in the nomenclature of different forces, my lord. Because there is a NIA, National Investigation Agency, there is SSPO.
What is CPO? What is this? I don't know. There are so many.
Now, my lord,
it seems to be quite confusing.
Very recently, they have clarified that, my lord. If lordship kindly turns to page 15 of my affidavit, my lord.
Lordship also on the last occasion.
1 second, I'll just.
Well, Mr. Chanda will come back to you. Don't worry. Let him say whatever he wants.
Advertisement types.
Yes.
Page 15, my lord.
Page 15.
This is dated March 2011, my lord.
Yes.
It says adoption of new nomenclature of Central Armed Police Forces. The terms like Central Police Organization (CPOs), Central Paramilitary Police Force (CPMF), and Paramilitary Force (PFM), Central Police Forces (CPFs), etc., have been interchangeably used while referring to the Central Police Forces, which are the armed forces of the Union, as also defined in the respective acts of the forces. This creates an incorrect perception about the central forces, and the expectation from the forces become unrealistic. Even in the international references, such incorrect nomenclature may cause confusion regarding the role of such forces, especially during elections, maintaining law and order, etc. The matter has now been considered in the Ministry of Home Affairs, and it has been decided to adopt a uniform nomenclature of Central Armed Police Forces, CAPF, while referring to Border Security Force, CRPF, CISF, ITBP, and SSB.
Yes.
Assam Rifles is excluded, my lord, from the definition. Henceforth, in all the references to the forces mentioned above, a uniform nomenclature of Central Armed Police Forces shall be adopted. Now, if lordship kindly turns to page 17 now.
Now, it doesn't say anything about Assam Rifles.
My lord, page 17 clarifies that.
Now, you say, if you start from the starting lines,
my lord,
the terms like CPO, CPMF,
PFMs,
and so on
and CPFs
have been interchangeably used with referring to. So
Central
would it
Police
not
Force.
mean these were used for even for Assam Rifles also at that point of time?
My lord, now this has been subsequently clarified, my lord. Page 17, my lord, kindly turns.
Page 17.
17. This is my lord. Subject regarding grant of ex-CAPF status to Assam Rifles personnel at par with other CAPFs. Come straight to para 4, my lord, if I may.
These are all notification by Ministry of Home Affairs.
Ministry of Home Affairs, my lord. Here it clear.
These are not under challenge.
Nothing is under challenge, my lord. It clearly says, my lord, the highlighted portion, Assam Rifle could not be included in the list of CAPFs due to its unique configuration and deployment in the northeast as a specialized counter-insurgency and border guarding force. The operational control vests with the Indian Army under Ministry of Defence, and at the same time, administrative control rests with the Ministry of Home Affairs.
Yeah, so two different aspects. We are not concerned with operational control. That is in a different area. Our is administrative.
But as far as the definition of
Service law,
CAPF,
promotion, these are all administrative. So we have nothing to do with operational.
but it is not included in the definition of or within the ambit of CAPF, my lord. And that order of 2012, my lord, only refers to CAPF, my lord. And it is also pertinent, my lord, that order, my lord, of 2012. Your lordship kindly turns to the writ petition, my lord, at page 15.
Yes.
Page 15 is the policy under which they are claiming, my lord. This talks about Central Armed Police Forces, my lord, in the heading itself. And your lordship kindly sees page 18, my lord.
Yes.
But at the bottom, my lord, it says to the Director General, CRPF.
Not been forwarded to Assam Rifles.
Not even forwarded to Assam Rifles, my lord. My lord, what is more relevant, my lord? Page 15, which I pointed out, my lord, that is of 2011, where definition of CAPF has been clarified, my lord.
Which you read out just now.
Page 15, my lord, which says that CAPF and uniform nomenclature only for these 5 forces, my lord. Assam Rifles is excluded, and soon thereafter this departmental exam has been issued in 2012, and specifically CAPF word has been used, my lord. So in my humble submission, my lord, this policy is not applicable to Assam Rifles. Government is very aware what is the meaning of CAPF, my lord, and they are excluded from the definition of CAPF. So this policy is not applicable to them. In fact, Assam Rifle is governed by a different set of policy where it is only for assistant commandant, and that is also 20%, not 17%.
So once this Annexure 3 is not applicable to them, they do not have a case.
They do not have a right, my lord. Something very similar they are claiming in the other writ petition, which has been dismissed by the other court, my lord, and that is pending on appeal.
That is also one of the issues, isn't it?
So in my humble submission, there is no case, but if they want to await for division bench order.
No, that is it becomes now. You see, the one thing is that if there is a view taken by a coordinate bench,
My lord.
this court cannot take a different view.
My lord.
Yes, Mr. Sando, we will have to wait for that.
My lord, that is there. I'll wait, my lord. One thing I'm showing. My lord, 6 CPC, report your lordship. What my friend says. In the second page, your lordship will find Ministry of Home Affairs. Second page.
Yes.
Ministry of Home Affairs.
Yes.
In the third page, your lordship will find, third page, in the middle 7.19.5.
Yes.
It is a, my lord, in the first page, your lordship will find 6th Central Pay Commission. In the first page, your lordship will find 6th Central Pay Commission.
Yes.
7.19.5. The ministry has 25 attached and subordinate offices and 3 allied organizations as under. Attached subordinate offices and allied organization under MHA attached and subordinate offices, Intelligence Bureau, Border Security Force, Central Reserve Police Force, Central Industrial Security Force, Indo-Tibetan Border Police, National Security Guard, Sashastra Sima Bal, Assam Rifle.
Yes.
Assam Rifle is at serial number 8.
Yes.
Bureau of Police, Research and Development, National Institute of Criminology and Forensic Science, Central Forensic Science Laboratory, National Crime Record Bureau. All these are subordinate and attached offices. Now, Lordship may
What is your submission?
Submission
On
this,
this,
all are working under the Ministry of Home Affairs. All are attached offices.
No, there is no dispute about that part.
And now I'll place your Lordship, just your Lordship, that compilation is there, KK Dination. KK Dination judgment is there. Just I'll read out the KK Dination judgment, what it says. (2008) 1 SCC. I'll read out only 4, 6 and para 24. And following that, my lord, even the other case went to Supreme Court. And para 4, 6 and 24. I'm just reading it, my lord. The nub of the grievance of the writ petitioner working in the rank of a radio mechanic in Assam Rifle was that the Ministry of Home Affairs and the Director General of Assam Rifle having accepted in principle that the members of Assam Rifle should be given the same rank and pay structure as was given to other central paramilitary forces. Yet the same had been denied to them. It was pleaded that the Ministry of Home Affairs had conveyed its decision to rationalize the rank structure of non-gazetted personnel of Central Paramilitary Forces by order dated 26/1/1998. Equal pay structure in other ranks, including the radio mechanics in Assam Rifles, could not be denied. His further grievance was that after the implementation of 4th Pay Commission, the pay of the Havildar GT and Head Constable radio mechanic was fixed in the pay scale of 975/1660 without any discrimination between the general duty and technical categories. But the discrimination surfaced when higher pay scale of 1200/2040 was given to the radio mechanics working in BSF. Denying the same pay scale to the radio mechanics in Assam Rifle, it was also pointed out that the radio mechanic working in Delhi Police Organization had been given a much higher pay scale on 10/10/97, which being denied to the similarly ranked holders in Assam Rifle. The writ petition was contested by the Union of India in the counter affidavit filed on its behalf. It was stated that on the recommendation of the 4th Pay Commission with effect from 1/1/86, Assam Rifle personnel had been granted revised pay scales and allowances entirely on the lines of other central paramilitary forces. However, as the changes, this is what meant. However, as the changes in the rank structure were not carried out, because nomenclature are different, therefore, carried out in Assam Rifle, like in other central paramilitary forces, a apparent disparity in the service conditions of the certain category of personnel, including the rank of radio mechanics, had arisen.
That is what they admit in their affidavit.
It is they filed the affidavit before the Supreme Court. And my lord, para 7 also, it was pointed out that Assam Rifle Directorate had brought this disparity to the notice of the Ministry of Home Affairs. In para 7 says, DGR has brought this disparity. It was also pointed out that Assam Rifle Directorate had brought this disparity to the notice of the Ministry of Home Affairs in February 1998 and had recommended the redesignation of radio mechanics and head constable in Assam Rifles as warrant officer. Here, my lord, Naib Subedar ought to have been sub-inspector, your lordship. Warrant officer and for replacement scale of so-and-so to bring them on par with their counterpart. In other central police organizations. it was stated that in response to the said recommendation, the Ministry of Home Affairs by letter dated 3/3/98 had informed Assam Rifle that they should redesignate the head constable radio mechanics as the warrant officer. They ought to have redesignated the Naib Subedar as sub-inspector. Provided their pre-revised and revised scales were identical to the pay scales of their counterpart in CRPF and BSF. CRPF and BSF. However, the redesignation of the rank could not be carried out. Redesignation of the rank could not be carried out in the light of the said communication, as there were disparity between the pay scales of the recommendees in Assam Rifle and counterparts in CRPF. Now 24, Your Lordship. Para 24, Your Lordship will find from the afore extracted paragraphs of the counter affidavit and the resume of correspondence referred to above, it clearly stands admitted by the petitioner herein that all the paramilitary forces, including Assam Rifle, are on a par with each other. And there was apparent disparity in the pay scales of personnel of Assam Rifle with their counterpart in other central paramilitary forces. In order to rectify this disparity, Director General Assam Rifle, petition number 2 herein by letter dated 18/2/98 had in fact taken up the grievance of the respondent with the Ministry of Home Affairs, interior recommending redesignation of Habildar RM, grade 1, grade 2 of Assam Rifle as warrant officer and for replacement of pay scale of so and so to bring them on par with their counterparts in other central police organizations.
That is with regard to pay scale, isn't it?
Not only rank structure also, same it should be. So it is at par. It should be grievance in para 4 and 6, Your Lordship have seen, grievances that it should be at par. And thereafter, my Lord, the Supreme Court has upheld that it should be at par 1 to 1. And therefore, even the other case, my Lord, it was before the division bench, the original judgment was had attained finality by dismissing the SLP in Arkanayar case. I have brought the judgment, Arkanayar case also, Your Lordship will find, to bring at par with same thing, Your Lordship. In the last part of the judgment, Your Lordship will find last page, my Lord, operative part of the judgment, para 14, my Lord.
Yes.
In the result, the petition stand disposal of with the direction to the respondent number 2, the Director General of Assam Rifle to take up the matter again with the respondent, that is Secretary to the Government of India, Ministry of Home Affairs, to bring parity in respect of the rank structure and pay of the Assam Rifle clerical cadre at par with CPOs by introducing rank of Assistant Sub Inspector or Warrant Officer at the entry grade with effect from 1/1/86 in the scale of so and so and or any other date as authority deemed fit and proper with all consequential service benefit in the light of the Government of India, Ministry of Finance resolution dated so and so communicated through Ministry of letter dated 10/10/97. The whole exercise would be completed within a period of 6 months from the date of receipt of a certified copy. That was, my Lord, finally implemented, but one part was not implemented. It was implemented initially on the before the division bench. What happened? The rank of promotion avenue up to the rank of second in command on the other day, which was before the division bench. Your Lordship was there. That was because they have issued the order and thereafter it is recalled. And here 7E, Your Lordship, para
this judgment is not reported anywhere.
My Lord?
This judgment is not reported anywhere.
No, not reported. My Lord, 7E
of this judgment. Yes.
Of this judgment. There is no marking 7E, my Lord. There is no pagination. Sorry, my Lord.
It's all right, no problem.
7E, my Lord.
Yes.
Lordship got 7E, my Lord. 7E.
Yes, yes.
As the petitioners are having similar recruitment qualification, past and performing similar nature of work, duties, responsibility like their counterparts in other CPOs, as ASI, which is evident from the Annexure 5, 7 and 8. The petitioner have equitably legal right for consideration of equal rank status in pay. Equal rank status in pay at the anti-grade and promotional avenues for promotion. Promotional avenues for promotion up to the rank of second in command.
That is your submission.
No, that was submission and bring parity. Bring parity.
No, but then that
the operative part, yes, this is submission, but operative part to bring parity, my lord. And my lord, G, lordship will find the next page G, my lord. The restructuring, G, the restructuring has been carried out in all central paramilitary forces to establish one-to-one parity with Delhi police. The order dated 10/10/95 for restructuring the CPMFs included the rank of ASI, which also exists in Delhi police. The 6th CPC also recommended that the post of ASI should exist in the executive orders. My sum and substance of my grievance, because to bring the specific direction, and this judgment was implemented. And even the promotion avenue up to the second in command, it is a Group A post that was granted initially by the MHA, but that was subsequently withdrawn when the SLP was dismissed, my lord. So my humble submission, if your lordship let it come after the judgment of the division bench.
Yes, it has to come after the judgment.
My lord.
But then, so this judgment has been partially implemented.
My lord, what I understand, my lord, the only issue by your lordship is rank parity has been given, my lord. Havaldar in Assam Rifle is getting same pay as Havaldar in BSF or CRPF or Delhi Police, my lord. Now the second question is whether promotional avenues will have to be similar also, my lord. That is the question, my lord.
The two different aspects.
In my ombudsman, they will do the different aspects, my lord. Only the parity in pay has been crystallized as a law, my lord. But parity in a promotional avenue, we are still far from that.
They admitted before the Supreme Court by filing an affidavit in the case of KK Dinesan. It should be at par. They made an attempt.
Whether there was same,
and so
same
Honorable
percentage
Supreme
of
Court.
promotion in CRPF and BSF,
Yes.
and whether this Honorable Court will go into that aspect. That is the only question.
Yes, that has gone by the Supreme Court itself.
Anyway,
KK Dinesan.
let us see what our division bench says, since the issue is pending there. And that matter is, promotion is the issue, isn't it? The other matter.
Yes, up to the second in command.
So that will have a bearing. That will definitely have a bearing.
After that,
You are not there in that division bench, my lord.
No, my lord, I am not. Mr. Devnath is appearing there.
Shall we record that this connected issue is pending before division bench, or shall we just adjourn it?
just simply adjourn it.
We'll just say on the request of both the parties.
After 4 weeks, let it come after 4 weeks, my lord. In the meantime,
This is met after 4 weeks.
but my humble submission, my lord, they cannot make a
You still have chance to argue after 4 weeks.
my lord.
Thank you. A lot of learning for the court. Thank you.
Obliged.
Item number 5.
So I was reading item number 3. I was reading item number 3.
Could not follow, Mr. Devnath?
So actually, I was reading item number 3.
3 on.
It's on.
Already gone.
You are not informed. It was urgent on behalf. You are for the petitioner.
Yes.
Not adjourned. Matter was called and I prayed for 1 week time also. I will the reply.
Any kind of disagreement between you?
No, no.
We'll have it. Yes.
5.
Yes.
Lordship, here in this case, Lordship, the petitioner.
Was it heard by any other bench at some point of time?
Yes, Lordship. The issue, the only issue left in this case whether I am entitled for interest or not, Lordship.
Interest on?
Interest on delay payment of service benefits, Lordship.
Delayed payment of service.
Service benefit, Lordship. Now, in this case, Lordship, the petitioner, he was an accountant working in the office of respondent number 4, Lordship, and he retired on 31st January 2014.
Yes.
After attaining the age of superannuation. Then, Lordship, my pension papers were processed from the block level to district level, Lordship. Then they were delaying the process, Lordship. Then I put up in representation before the authorities, Lordship, in the year 2017. Then still they are not doing anything. Then I approached this honorable court, and this honorable court has directed the authorities to dispose of my representation.
In an earlier round of litigation?
Yes, Lordship. Then, yet they did not comply the order. Then I have to file contempt, and during the pendency of the contempt, Lordship, they have passed the impeachment order which I have challenged in this writ petition, Lordship. In 2019, they have passed the order saying that since I am facing a criminal case, that is why they have decided, they have passed the order for granting provisional pension as per Rule 64 of the Civil Service Pension Rules. Now, my only argument before this honorable court, Lordship, what they have invoked, Rule 9. Rule 9 is the power of the same rules, and 64 is the procedure for grant of provisional pension. My contention is that Rule 9 says that the proceeding has to be pending before the date of the retirement. My case, what happened, I have retired on 31st January 2014, but the criminal proceeding was initiated in May 2014. That means after the date of my retirement, Lordship.
Initiated means that was criminal proceeding?
Just file the FIR, Lordship.
So FIR came after your retirement?
After my retirement, Lordship. Then what the Rule 9 says, Lordship. That is, my Lord, in the counter affidavit, my learned senior has quoted the rules.
The rule has not been appended. It's been
Quoted, Lordship. Is in the, yes,
You will find
page 5.
Page 6 of the affidavit filed by the state.
6. So before that, I'll just read out from page 5, Lordship. State affidavit.
Yes, 1 minute. Yes. State means restaurant number 4.
Lordship, yes.
Yes, Lordship.
Yes.
I'll read out para 11, 12, that is page 5, Lordship. Then after that, I'll come to that rules, Lordship.
Para 11.
Para 11, 12, yes, Lordship. In reply to para 11 and 12, it is
Why
humbly
these
submitted.
paragraphs are marked like this?
Pardon, Lordship.
Why these paragraphs are marked like this? 7, 10, 11, 12, so what?
The government has filed the affidavit, Lordship.
Okay, yes.
Lordship, in fact,
I've taken reference from the writ.
this was filed during the COVID time.
It's
Lordship, and then proper.
It's all right, it's all right.
It is humbly submitted that the petitioner has concealed the fact that a case pending against him before the court of first class magistrate at Chora. The respondent number 4 has filed the FIR dated 8/5/2014
Yes.
and 13/5/2014 due to the fact that the respondent number 4 found out that the petitioner has been fraudulently forging the signature of his controlling officer for his unlawful enlistment. It is brought to the notice of this honorable court that the case has been charge sheeted by CS number 13 2016 dated so and so. That is the date of the charge sheet, Lordship.
Yes.
FIR was filed May and case was charge sheeted on 2016. And is still pending in the court of first class magistrate Shohara. It is further brought to the notice of this honorable court. The respondent have granted the petitioner his provisional pension but withheld his gratuity in terms of Rule 9 and 64 of the Meghalaya Civil Service Pension Rules hereinafter quoted, Lordship. Now, Rule 9 says, Lordship? Right of governor to withhold and withdraw pension. Lordship, the head notes is very important, Lordship. The right of governor to withhold and withdraw pension. The governor reserves to himself the right of withholding or withdrawing a pension or part thereof, whether permanently or for a specified period, and of ordering recovery from a pension of the whole or part of any pecuniary loss caused to the government if in any departmental or judicial proceeding the pensioner is found guilty of grave misconduct or negligence during the period of his service, including service rendered under re-employment after retirement. This Rule 9(1) says, Lordship, that after the conclusion of the trial, whether it is a departmental proceeding or the judicial proceeding, if it is found that the pensioner was guilty of grave misconduct, then they can withdraw and withhold or can direct for recovery of the misappropriated amount, Lordship. This rule will come after the conclusion of the trial. Now, Lordship, below down, Lordship, 2.
Yes.
A, Lordship. The departmental proceeding referred to in Sub-Rule 1, instituted while the government servant was in service, whether before his retirement or during his re-employment, shall after the final return of the government servant shall be deemed to be proceeding under the rule and shall be continued and concluded by the authority to which they were commenced in the same. This is talking about that departmental proceeding, Lordship. I was not facing any departmental proceeding. I was facing judicial proceeding. Now, Lordship, now 4, Lordship. 4 is very relevant, Lordship. In the case of a government servant.
Where is 4?
4, Lordship, down below, Lordship. 3 and then 4, Lordship. Same rule, sir. In the same page, Lordship, page 7. This is a sub rule.
Yes.
In the case of a government servant who has retired on attaining the age of superannuation or otherwise, and against whom any departmental or judicial proceedings are instituted, or where departmental proceedings are continued, under sub-rule so-and-so, a provisional pension as provided in Rule 64 shall be sanctioned. The interpretation of this rule, Lordship, here the rule is very clear, says, in the case of a government servant, then first he has to be a government servant. Then on the date of his retirement, he should have some pending proceeding against him. Then in that eventuality, the government can invoke the power of invoke the Rule 64.
So you had no proceeding pending against you?
On the date of my
retirement.
So in that eventuality, Lordship,
that they could not have resorted to Rule 64.
Yes, 64. This 64 will only be applicable to the government servant, and if some proceeding is pending on the day of retirement, then only they can invoke.
You have said it was not proceeding. So right.
Yeah, yes, Lordship. Now, 60 down below, Lordship, the interpretation of this rule is given here, Lordship.
Where?
Next page 8, Lordship.
Yes.
Grant of provisional pension in the event of proceedings.
64.
No, just above 64, Lordship. Just the preceding para of 64, Lordship.
At page 7.
8, Lordship. 8, Lordship.
What he starts with?
Lordship, the grant of provisional pension in the event of proceedings.
You are referring to page 8 of the same.
Yes, Lordship.
It's something different here.
My Lord,
It starts from
this is the one, Lordship.
page 8 is something different here. It's a part of the affidavit, government affidavit, isn't it?
Yes, yes.
No, but then here, see, the page 8, the first word here is gratuity, comma, shall, however we pay, it starts with that.
That is a provisional pension where departmental judicial proceeding may be pending.
Yes, that is what the page 8.
My Lord, there are
That is
two
what the page 8.
Lordship,
Lordship,
there are two
maybe-
affidavit file, one through online mode and another.
One is an unsigned affidavit, Your Lordship, during the COVID time,
No, you
and
are-
then subsequently we file a proper affidavit. Lordship will have the unsigned one, Your Lordship. It's same.
No, which one you are referring now?
I am referring that file one, sir, Lordship. They have filed 4th March 2022, Lordship.
No, you please refer to the affidavit file on 3/11/2020, Your Lordship.
Online mode that is.
Maybe Your Lordship has got that affidavit which was filed on
By email.
by email on November
Lordship.
2020.
Because that was unsigned, Lordship. Subsequently, they have filed that signed affidavit, Lordship, that is 4th March 2022, Lordship. Now I'll just read out, Lordship.
It's all right. Yes.
Now another aspect, Lordship. Now when it can be said that judicial proceeding has been instituted, Lordship, when it can be said, whether on the mere filing on the FIR or on the filing of the charge sheet, that is a B, Lordship.
Okay. Judicial proceeding shall be deemed to be instituted. Yes.
Yes, judicial proceeding shall be deemed to be instituted in the case of a criminal proceeding on the day on which the complaint on the report of a police officer on which the magistrate has taken cognizance is made. Here, admittedly, Lordship, charge sheet was filed on 2016. After that, the court has taken the cognizance. Mere filing of the FIR cannot be said that judicial proceeding is pending against me. Now, the interpretation of rule that
No, but then in your case, FIR also came after your superannuation.
Yes.
So, why to go into all those things? Unnecessary.
no,
If that
Lordship,
be the thing.
why I am saying, Lordship,
Yes.
now this is my pensionary benefits, whether they can withhold without any authority of law. There has to be some sort of law for withholding my pensionary benefits.
That is what. That is your. This court has got your point.
Yes, Lordship. Now, rule to grant of provisional pension in the event of proceedings, where departmental or judicial proceeding instituted. Very clear, Lordship. During the service of the government servant are not likely to be finalized by the date of retirement.
You are reading which part?
Same affidavit, Lordship, that is just below this one.
No, which page? Which page?
Page
is
8, Lordship.
Page 8.
8.
Subclause 2. No.
2, yes, Lordship.
Grant of provisional pension in the event of
Proceedings. Where departmental or judicial proceeding instituted during the service of the government servant are not likely to be finalized by the date of retirement, action to grant provisional pension should be taken so that the returning government servant may not be put to undue hardship. No gratuity, however, shall be paid either by the head of the office or by the head office until the conclusion of the Department of Judicial Proceedings and the issue of final orders thereon. Here, interpretation of rule is very clear that it has to be during the period of his service.
Yes. It's all right.
So now, 64 they have invoked, Lordship. That too also in the year 2020, only for a period of 6 months. After that, the provisional pension was not extended, Lordship. Now first, from 2014 till the intune order was passed, There nowhere says that your pensionary benefit was withheld because of the pendency of so and so. In 2020 only, they have passed the order saying that since you are facing some proceeding against proceeding, that is why we are giving you provisional pension, not the final pension. That provisional pension also after that not extended, Lordship. Now, Lordship, that the trial which I was facing ended with the acquittal.
If that is, see, do you regret to go into all those things?
Yes, Lordship. Why I am saying, because my only contention is that whatever the action they have taken, these are all illegal. Because the government does not have the power.
That is what you have said already.
Yes, does not have the power to invoke all those rules. If
the outcome in the criminal case, whether it will have a bearing here.
Yes, Lordship.
What? Which way?
One judgment is there, Lordship. They have interpreted the word fault. Because the Payment of Gratuity Act, I am talking about the Payment of Gratuity Act, Lordship. The section 7, subclause 3 says that if the fault lies with the employer, then they have to pay the interest. And if the fault lies with the employee, then the department is not liable to pay the interest. Now this judgment, Lordship, says they have interpreted, the judgment has interpreted the word fault. Fault. It says that if the criminal proceeding concluded or culminated into the acquittal of the employee, then in that case, it can be said that the fault lies with the employer.
Acquittal means even if it is benefit of doubt also.
Lordship, they have not mentioned anything, only say that if the proceedings culminated with the acquittal of the. So that part, that judgment is, I am relying that the gratuity is, for so far as the gratuity is concerned, I am entitled for interest, Lordship.
Where is that judgment?
Lordship, that is 2013 3 SCC 472.
What is the page number, say?
Lordship, that relevant para would be 20, Lordship.
Yes.
That our determination of the first ingredients is as follows. We are of the considered view that the consequent upon the acquittal of the appellant by the Special Judge CBI Court, Chandigarh, it would be erroneous to conclude that the gratuity payable to the appellant on 18 days of superannuation, that is so-and-so, was withheld on account of some fault of the appellant himself. We may hasten to add, if the appellant had been convicted by the Special Judge CBI Court, Chandigarh, then the first ingredient would also be deemed to have been satisfied. Conversely, because the appellant has been acquitted, he cannot be held to be at fault. Accordingly, it emerges that the fault ingredient of the employee himself for denial of gratuity when it becomes due remains unsubstantiated. Since one of the two salient ingredients of the proviso under subsection 3A of section 7 of the Gratuity Act is clearly not satisfied in the present case, we are of the view that the appellant cannot be denied interest under proviso to section 7 3A of the Gratuity Act. Accordingly, the appellant has to be awarded interest under section 7 3A of the Gratuity Act. Therefore, if the provision of the Gratuity Act are applicable to the appellant, he would most definitely be entitled to interest under subsection 3A of section 7 of the Gratuity Act on account of delay payment of gratuity. Now, Lordship, now I am referring one judgment, Lordship, that is SCC 2013, volume SCC 2013,
Yes.
volume 12, page 2110.
2-1?
Sorry, 210, sorry, 210. Lordship.
Yes.
Here relevant para, Lordship, the operative part will be para 10, Lordship.
Para 10.
10, I'll just read para 10, 11, 12, 13, 16, 17, 18, Lordship. Here says that in absence of a specific rule, they cannot withhold the pensionary benefits.
But then there are rules here.
No, that is why I am saying, my lord, the rule says, Lordship, during the time of my...
They have invoked Rule 64, isn't it?
Yes, Lordship.
Then
that rule says when I was...
that is okay. It would attribute to, see, they basically whether they are right or not, that what is to decide.
Had that
But
rule...
it is not a case that there was no rule.
No, my lord, true, my lord. But that rule is not talking about that proceeding is to be instituted after the date of my retirement.
Yes.
Only says everything has to be prior to the date of my retirement. The rule is silent. Had the rule...
silent means?
The rule is not talking about that to be instituted after the date of my
So
retirement.
once no power is there, that action will be wrong then. It will be held to be wrong. Then what is the question? In absence of rule means what? Rule is there.
That Lordship, that I'll just read out para.
Yes, read out. Say, why to unnecessarily burden the court with so many judgment if it is not applicable? Yes, read out.
The present case is admittedly governed by the Bihar pension rules applicable to the state of Jharkhand. Rule 43(2) of the said pension rules confers power of the state government to withhold or withdraw a pension for part thereof under certain circumstances. Rule 43(b), Lordship, that is Rule 9(1) of our pension rules. The state government further reserves the right to, that is not relevant, Lordship. Then para 11, from the reading of the aforesaid Rule 43(b), the following emerges. The state government has the power to withhold or withdraw pension or any part of it when the pensioner is found to be guilty of grave misconduct either in departmental proceeding or judicial proceeding. This provision does not empower the state government to invoke the said power while the departmental or judicial proceedings are pending. The power of withholding leave encashment is not provided under this rule to the state irrespective of the results of the above proceedings. This power can only be invoked only when the proceedings are concluded, finding guilty and not before. Therefore, there is also a proviso to Rule 43(2) which provides that such departmental proceeding, if not instituted while the government servant was on duty either before or during re-employment, shall not be instituted. That is not relevant, Lordship. Then para down, Lordship, B. Judicial proceeding, if not instituted while the government servant was on duty either before or during re-employment, shall have been instituted in accordance.
Where is it?
That
Achha,
para-
if not insured,
Yes,
12B.
Yes, Lordship. Para 13, Lordship, now. According, a reading of Rule 43B makes it abundantly clear that even after the conclusion of the departmental inquiry, it is permissible for the government to withhold pension only when a finding is recorded either in departmental inquiry or judicial proceeding that the employee had committed grave misconduct in the discharge of his duty while in service. There is no provision in the rule for withholding of pensionary or gratuity when such departmental or judicial proceedings are still pending. Then para 16, Lordship. The fact remains that there is an imprimatur to the legal principle that the right to receive pension is recognized as a right in property under Article 300A of the Constitution of India, which reads that under. That is the provision, Lordship, that 300A. Once you proceed on that premise, the answer to the question posed by us in the beginning of the judgment becomes too obvious. A person cannot be deprived of his pension without authority of law, which is the constitutional mandate enshrined in Article 300A of the Constitution. It follows that attempt of the appellant to take away a part of pension or gratuity or even a leave encashment without any statutory provision under the umbrage of administrative instruction cannot be countenanced. It hardly needs to be emphasized that the executive instructions are not having statutory character and therefore cannot be termed as law within the meaning of the aforesaid Article 300A. On the basis of such circular, there is
not here. It has no bearing of those.
Lordship, this is why I am saying judgment says that when the matter was pending, when any criminal proceeding was pending, then the court cannot, the government cannot issue any order withholding my pension, because the rule is not saying that they can exercise the power when had it been mentioned in the rule that is to be instituted after the retirement, then they could have, Lordship.
Yes, anything else? But then, where is your thing? Those impugn orders and all those things. You have not taken us to all those things. You have come to. Where is those?
That is, Lordship, page 44, Lordship. 44, 45, and 46.
Of your affidavit?
In my counter.
Oh, sorry, sorry.
Yeah, sorry, in
You
my
have to file a joint
petition, Lordship.
What is the judgment dated 10/3/2023 which you have?
Yes, that is at page, Lordship.
What is the judgment?
Lordship.
There is an affidavit filed by the petitioner to bring on record the judgment dated 10/3/2023.
10-3.
That is the judgment of acquittal by the learned judicial magistrate, Your Lordship. That is by way of an addition.
Affidavit, Lordship.
And these are not disputed facts, is it?
Yes,
No,
Lordship.
we are not disputing, Your Lordship.
Page 44, Lordship.
Of your writ petition?
Yes, Lordship. This was passed after the disposal of the first round of writ petition, Lordship.
Page 44?
44, Lordship.
What is page 41 then?
41, the order passed by this court, Lordship, directing the respondent authority to dispose of my representation, Lordship. And in compliance of this, they have.
Yes.
Page 44, Lordship. For that order, Lordship. That order is at operative part is 42, Lordship. Order is at
28 November 2019?
Yes, Lordship. 20. Yes, Lordship. That may I read the content, Lordship?
Sure, please.
Then after that, Lordship, next page, Lordship, that is order dated 21st February 2020. Here they have first the order for granting provisional pension, Lordship.
So this is also impugned by you?
Yes, Lordship. Followed by another order, Lordship. Lordship, here in the page 45,
Yes.
serial number 3, Lordship, they have quoted the Rule 70. The Rule 70 says only for 6 months.
Okay. Then what happens thereafter?
After that, even that provisional pension was also not extended to me. After that, it stopped, Lordship.
So there is no pension now?
No pension, Lordship.
They have withheld totally?
Totally, Lordship. Then, page 46, Lordship. Here, serial number 3, Lordship, proposal at ES, that is for grant of provisional pension for 6 months. Provisional pension may be released for a period of 6 months, while further clarification will be taken from the government for the period beyond 6 months from the date of, Lordship, retirement, Lordship. Because the provisional pension cannot be granted beyond 6 months from the date of retirement, Lordship. The rule, that is why it says that if any proceeding is instituted prior to the date of retirement, so that the government servant should not suffer for pendency of the case. That is why the provisions for provisional pension, Lordship. Now I have retired on 2014. Now they are decided to grant provisional pension for a period of 6 months from the date of retirement, Lordship. Then from 2014 till date, Lordship, they have illegally withheld, Lordship, my retirement benefits. Had they given the provisional pension?
Yes. Anything else? That much? What is your prayer in the writ?
That is at page, Lordship, 15, Lordship. I made prayer for interest, Lordship, in basic.
Yes, yes.
Prayer is
That's-
yes.
Yes, Mr.
May it please your Lordship. Lordship, here in this case, my humble and respectful submission is it needs their interpretation of Rule 9, sub-rule 4, your Lordship. Because what happened, your Lordship, the petitioner herein was about to retire on 31st January 2014, but continued to draw his salary till March 2014.
He was due to retire on?
Yes, there was a dispute. He raised a dispute regarding his actual date of birth. Then we took the decision that the date of retirement of the petitioner shall be based on the certificate issued by the Meghalaya Board of School Education. That is 31st Jan 2014. He disputed and then he got the salary up to March 2014.
But then what you have held? What according to you, what should be his date of retirement?
We have taken the date of his retirement on 31st Jan 2014. Lordship, yes. Then what happened, your Lordship? Then later on, after he retired, your Lordship, it was detected that he forged the signature of the controlling officer. Then immediately an FIR was lodged before the Sora police station. Sora police station. Because of dependency, because of that criminal proceeding, Your Lordship, that is why his pensionary benefit has been stalled, Your Lordship, has been kept in abeyance.
But then that has been detected after his retirement.
Lordship, that is what Lordship, I submit, Your Lordship. It needs the interpretation of Rule 9(4). Kindly come back to page 7, Your Lordship. Sub rule 4. Lordship, kindly see
This one. Just give me time to come to that rule.
Lordship, that is at page 7 of the unsigned affidavit filed by the state.
Email affidavit.
Yes, Your Lordship, email affidavit. At page 7, Your Lordship.
Yes.
Lordship, this is right of governor to withhold or withdraw pension. That is Rule 9. Then, Lordship, kindly come to sub Rule 4. Lordship, kindly see the construction of the sentence, Your Lordship.
Yes.
The framer of the rules, Your Lordship. Lordship, kindly see, in the case of a government servant who has, Lordship, kindly, there is a word has.
Yes.
Retired on attaining the age of superannuation or otherwise, and against whom any departmental or judicial proceeding are instituted. Lordship, kindly see the sentence. The sentence, yeah, the construction of the sentence. All, Lordship, in the first, Your Lordship, has in the past tense, Your Lordship, and are instituted in the present tense, Your Lordship. Are instituted or where departmental or are continued under sub rule to a provisional pension as provided in Rule 64 shall be sanctioned. Your Lordship, because this rule, Your Lordship, this rule permit us, Your Lordship. Rule 64, Your Lordship, kindly turn to 64. That the rules there. Kindly see 64B, Your Lordship. No gratuity shall be paid to the government servant until the conclusion of the departmental or judicial proceeding and issue of final order thereon, Your Lordship. It is not a case, Your Lordship, that we don't have the power. The power is there with the government to withhold.
That is all right.
Withhold, Your Lordship.
The contention is that contention of the petitioner is that there was no proceeding pending against him.
Lordship, kindly see
on the date of his retirement.
Kindly see, as I have submitted, Your Lordship, the construction of the sentence in sub rule 4.
Your case is mainly based on that sub rule 4.
Lordship, kindly see, in the case of a government servant who has retired on attaining the age of or otherwise, and against whom any departmental or judicial are instituted. Can you see, Your Lordship, are instituted in May 2014?
So you want to say, if a person retires today and after 10 years you detect some mistake?
No, Your Lordship. It's not a case. It is not a case of 10 years.
No,
it is a case on only 2 months, 3 months, Your Lordship. While the person was being processed, Your Lordship. This was detected, Your Lordship.
It may happen that you process something after many years. So you can resort it and then stop payment of a pension there.
No, Your Lordship. It is not. That is not the case here, Your Lordship. The case here is only the hardly. It's only 2 months.
In kind of interpretation you are trying to give it to this sub rule 4 of rule 9. That would mean that way.
Who has retired?
We can say that the government will always have that option with them. With it.
Can you see, Your Lordship, the construction of the sentence? Who has retired and against whom a departmental or judicial proceeding are instituted?
We read it simultaneously. So we say are instituted on the day of return.
No, it does not say so, Your Lordship. In the case of a government servant who has retired on attaining the age of superannuation or otherwise, and against whom any departmental or judicial proceeding are instituted. Lordship, it's a in the words that is in the present form, Your Lordship. In the present tense, Your Lordship, are instituted, not were instituted. Are instituted. Can you see, Your Lordship? Then, Your Lordship, That power is there. As I have submitted, Lordship, will resort to Rule 64. Then what does it say, judicial proceeding? Then Lordship kindly come to 4B or 5B.
Now, that is the stand you have taken in your affidavit of opposition.
Lordship, yes.
Then?
Judicial proceeding shall be deemed to be instituted.
You are referring to 5B.
5B, Your Lordship.
No, there is 6B is there. 5B.
Oh, sorry. 6B, yes. A judicial proceeding shall be deemed to be instituted in the case of criminal proceeding on date on which the complaint or report of a police officer. Lordship, kindly see, Your Lordship. Once the FIR is filed, Your Lordship, then
on which the magistrate read it.
On which the magistrate take cognizance is made. In the case of a criminal proceeding, on date on which the complaint or report of a police officer. What is a report of the police officer? The moment the moment the FIR is forwarded, then is forwarded, Your Lordship, because
what is the report? See, like report, you have to come to section 173 CRPC. See, what is a police report after investigation? Does it mean a forwarding report?
Reports, if we go by 173, that means it's contained the charge sheet, Your Lordship. It contains the charge sheet and the statement of various. But can you see, Your Lordship, in the
question of see, like if you read together all those things, question of taking cognizance. At what stage?
Lordship, in my humble and respectful submission, Lordship, once an FIR has been filed and forwarded to the magistrate concerned, Your Lordship, that is the cognizance, Your Lordship. He takes the cognizance. He takes the cognizance. Because Your Lordship, otherwise the police officer will not have the jurisdiction to commence the investigation, Your Lordship.
That will be your submission, but then taking cognizance of FIR and taking cognizance of a case are two different things.
Can you see, Your Lordship, section 154
of CRPC?
Yes, Your Lordship.
Yes.
May I read it, Your Lordship?
Yes.
Every information relating to the commission of a cognizable offence, if given orally or to an officer in charge of a police station, shall be reduced in writing by him or under his direction, and be read over to the informant, and every such, whether given in writing or reduced in writing, shall be signed by the person giving it, and the substance thereof shall be entered in a book to be kept by such officer in such form as the state government may prescribe in his behalf.
Yes.
So, Your Lordship, the FIR was filed on 18/5/2014.
Yes.
You
are reading of 154. What you are trying to point out from?
Lordship, that this is because the offence alleged to have been committed at that particular time is a cognizable offence, Your Lordship. It is a cognizable offence, Your Lordship.
It's all right. Cognizable offence. That is why police has the power to investigate.
Yes.
Otherwise, without the authority of the magistrate, they cannot.
Because of this, Lordship, because of this pendency of that criminal proceeding, as I have submitted, Your Lordship, that is why their pensionary benefits, Your Lordship, including gratuity, has been withheld. By taking recourse to Rule 64 of the Pension Rule of 1983.
That is what is to be decided here.
Yes, that is, Your Lordship, it is an interpretation. Because it is not the case that we don't have the power. The power is there, Your Lordship. We exercise that power. And, Lordship, the submission has been advanced that the petition is not at fault. It cannot be said, Your Lordship, in my humble and respectful submission, Your Lordship, it cannot be said that the petition is not at fault, Your Lordship. The petitioner is wholly responsible for this.
For what?
for dealing for delay of delay payment of his pensionary benefits.
Why?
Lordship, kindly see, Lordship, we detected detected that something has been done by him immediately after his retirement in May 2015 of 2014. We lodged the FIR, Lordship, and we stalled the pensionary benefits by taking recourse to Rule 64 of the Pension Rule of 1983.
Then which way you are blaming petitioner? Why you are blaming?
Lordship, because
that action is by you.
The proceeding is going on, Your Lordship. It is the proceeding is going on, and Your Lordship, even in the judgment of acquittal, also it is not a case of clear. It is not a case of clear and honorable acquittal, Your Lordship.
But the rules is only acquittal.
Lordship.
Rule speaks about acquittal.
Lordship, kindly see, Your Lordship, the judgment of the learned trial court, Your Lordship. It is on.
No, that is all right.
It's on the benefit of doubt, Your Lordship. Right. It's on the benefit of doubt, Your Lordship.
But then, if you refer to the pension rules, it is only acquittal. It doesn't say anything about that. It doesn't elaborate.
Lordship, like Lordship, in the case of appointment, Your Lordship, if a person is facing a criminal trial, Your Lordship, the Honorable Supreme Court will have to determine whether it is honorable, honorable or.
There is a law holding that.
Yes.
But then, if you say this, then please us something, give us something that we
Lordship.
Same interpretation will.
Lordship, because I'm relying on one judgment of the Honorable Supreme Court, Your Lordship, regarding when there is a rule, Your Lordship, a rule to withhold, then Your Lordship, the government cannot be faulted with, Your Lordship. Lordship, kindly.
So it can be exercised arbitrarily whenever the rule is there, you stop it.
Can we see, Lordship, this? If Lordship kindly come to part 6 of that judgment.
Yes.
The order of the tribunal in the main matter and the review petition are challenged in this appeal. Long after these SLP were filed in this court, the appellant was acquitted in the criminal proceeding by an order dated 23/1998. Thereafter, the appellant has been paid the full pension as well. Lordship, in this case, Your Lordship, the petitioner is getting the regular pension now, as well as gratuity and other consequential. In the present case, the appellant now claims for the first time that he should be granted interest on the gratuity which was held during the pendency of the criminal proceeding. He claimed interest for the period of so-and-so, that is to say the date of his retirement, dated so-and-so, when gratuity was paid. The only other condition raised before us is that he should be granted all monetary benefit on the basis of his entitlement to promotion to the post of Joint Secretary in 1980. This condition was rejected by the tribunal. The payment of gratuity was withheld in the present case since the criminal proceeding was pending against the appellant when he retired.
When he retired?
When he retired. Rule 52 1C of the AP Revised Pension Rule 1980 expressly permit the state to withhold gratuity during the pendency of any judicial proceeding against the employee. In the present case, apart from Rule so and so, there are also an express order of the tribunal which was binding on the appellant, and the respondent under which had directed the debt so and so was not to be paid to the appellant till the judicial proceeding were concluded and the final order was paid. In view of this order, as well as in view of rule, it cannot be said that there was illegal withholding of gratuity by the respondent in the case of the appellant. We therefore do not see any reason to order payment of any interest on the amount of gratuity so withheld.
There are two aspects, two different so far as the facts of the cases are concerned. The facts before the apex court, the case, because that there is a proceeding pending when the petitioner retired. This is one thing. And second thing is that the department waited till the criminal waited for the disposal of the criminal case. Then in such a situation, the apex court said no. In such a case, you cannot hold the department.
Can you see, Your Lordship, here? Can you see here also, Your Lordship? The criminal proceeding is pending against him, Your Lordship.
But then that is when he instituted after his retirement. Now that is the crux of the issue.
Because, Lordship, because as I have submitted the construction of the sentence in sub rule 4 of rule 9, Your Lordship, is very clear, Your Lordship. It's very clear, Your Lordship. Who has an R?
It is clear for you, Mr. Shulai.
If Lordship, whole otherwise,
unless you bring something to show that has to be interpretation, the way you say it, then only. Otherwise, I don't think. This code is not very much convinced.
Because that power is, sub rule 4 is very clear, Your Lordship.
It cannot be.
Because while he was in
Cannot be
service, this thing was
not properly worded, but then I don't think the interpretation which you are trying to give it is correct.
because Your Lordship, can you see has and are. If Lordship holds otherwise, then I have no place.
That is what is to be done. But then anything in your support, which way it is to be interpreted?
Lordship, in my humble and respectful submission, it has to be interpreted because the wording of the rule is has. That means in the past tense, and the continuing sentence is in the present tense. Your Lordship. So, in spite of the fact that he has retired and the judicial proceedings are pending, Your Lordship, that power is there with the state government, Your Lordship, to withhold their pensionary benefits, Your Lordship. It is not a case of, it is not the fault of the government, it is the fault of the petitioner himself, Your Lordship. Even the judgment of acquittal also, Your Lordship, is not honorable. It is on a benefit of doubt, Your Lordship. So my humble and respectful submission, Your Lordship, the petition lacks merit, Your Lordship.
You want to say, if it is not a clear acquittal, then...
Lordship, yes, he cannot claim interest, Your Lordship. He cannot claim interest, but he is getting the regular pension, but not the interest, Your Lordship.
I will get the regular pension today as per my instruction, Lordship. Most probably I will get the regular pension today, Lordship.
You are getting a pension, that is what it is.
Today, I'll get
because
today,
we have issued, after the judgment of acquittal, Your Lordship, we have issued, Your Lordship, for payment of regular pension.
Differentiate, Lordship, little bit, Lordship, 2 minutes, Lordship. That rule what my learned senior referring as well as I am also referring rule 9, Lordship.
Yes.
The head note, Lordship, kindly see the right of governor to withhold or withdraw pension. The rule 9 says pensioner, Lordship. The wording pensioner, Lordship. That is why I said, Lordship, that rule 9 can be invoked against a pensioner after the retirement, Lordship. If there is a finding, either by the departmental proceeding or judicial proceeding that he has committed grave misconduct, then only they can invoke rule 9 against the pensioner, Lordship. Now rule 9(4), Lordship, talking about a government servant. I was a government servant.
There is a distinction between these two words.
Yes, Lordship.
Pensioner and the government.
Yes, Lordship. 9(4) say against a government servant, Lordship. I was not a government servant when the order was passed, Lordship.
Yes.
I was a pensioner, Lordship. So, and we have to read this rule for, Lordship, in the case of a government servant who has already retired on attaining the age of superannuation otherwise end, Lordship, we have to read conjointly, Lordship.
It's a conjoining thing.
Conjoining, Lordship. He has retired and on the date of retirement he was facing some proceeding. Then in that eventuality they can invoke the power under rule 64, Lordship. I was not a government servant. Moment I retired, I was a pensioner, Lordship. So they cannot invoke that rule, Lordship.
Moment you become a pensioner, he ceases to be a government servant. Anything?
That's all, Your Lordship.
Nothing on pensioner and government servant.
And so far at that taking cognizance also, Lordship, when the cognizance is to be taken, there are so many judgment, Lordship, on that issue, Lordship.
I don't think the court has any confusion with regard to that. Mr. Shulai may say otherwise. You will say something to it.
Lordship, I just refer some more judgment, Lordship. Two more judgment, Lordship, and very small judgment, not that.
What for? On what point?
That is delay payment of, in order to...
The interest?
In the, yes, Lordship. Delay payment for...
That is more important for the lawyer.
Two more, Lordship, that...
yes.
That is...
have you given a list of books?
Yes, I have given, Lordship. I have given, Lordship.
You have to place it on record.
Yes,
you have to place it on record.
I have. I've given the list of.
Give me. What are the decisions? Where are
Lordship, that is 2014 8 SCC.
What does it say about?
This is also delay payment of payment and pension and gratuity, Lordship, if there is a delay. That here, Lordship, that is the page para 4, Lordship.
Yes.
They have quoted some earlier judgment, Lordship. That
Para 4 of the judgment.
Yes, Lordship. The learned judge has allowed the writ petition by order response after setting aside the action of the respondent in withholding the amount of gratuity and directing the respondent to release the withheld amount of gratuity within 3 months without awarding interest as claimed by the appellant. The High Court so and so. Now, the pension and gratuity are no longer any bounty to be distributed by the government to its employees on their retirement, but has become, under the decision of this court, valuable rights and property in their hands. And any culpable delay in settlement and disbursement thereof must be visited with the penalty of payment of interest at the current market rate till the actual payment is made to the employees.
So what is the current market rate?
If it is, Lordship, it varies, Lordship, because so the FS court in some cases.
That will be on the, it varies. So it will be on the day of the hearing or day of the judgment.
At the current market rate on the day of the judgment, Lordship.
So we'll we'll record it on the day of judgment.
And one more, the 2008 3 SCC 44, Lordship. This also says same, Lordship, that I am entitled for interest if there is a delay, Lordship.
What is the other decisions here?
That 2008 3 SCC. Here, Lordship, I'll just read the head note, Lordship.
Go ahead now. What is the relevant paragraph?
Then para here, Lordship, 13 to 17, Lordship.
Para 13 to 17?
Yes, Lordship. The para 4 is important, Lordship. 14. In the circumstances prima facie, we are of the view that the grievance voiced by the appellant appears to be well founded and we would be entitled to interest on such benefits. If there are statutory rules occupying the field, the appellant would claim payment of interest relying on such rules. If there are administrative instructions, guidelines, or norms prescribed for the purpose, the appellant may claim benefit of interest on that basis. But even in absence of statutory rules, administrative instructions, or guidelines, an employee can claim interest under Part 3 of the Constitution of India, relying on Article 14, 19, and 21 of the Constitution. Now another
para 40.
Para 14, Lordship. Now, Lordship, another aspect, Lordship.
You have relied on 2008 CSCC page 44.
44, yes.
And you read out paragraph?
14, Lordship. 1-4.
1-4.
1-4.
Okay, sorry.
Lordship, one more with regard to the gratuity, Lordship. Whether the Section 7, Clause 3A is a directory or mandatory. That it says that it is a mandatory, Lordship. It does not lie with the discretion lies with the. I'm just relying para 7 of the judgment, Lordship.
What is the judgment? What is the citation?
The citation is, Lordship, 2003, 3 SCC, page 40, Lordship, 40. Here, Lordship, para 7. May I read, Lordship?
Yes.
It is evident from Section 7(2) that as soon as gratuity becomes payable, the employer, whether any application has been made or not, it is obliged to determine the amount of gratuity and give notice in writing to the person to whom the gratuity is payable and also to the controlling authority specifying the amount of gratuity. Under Section 7, subclause 3, the employer shall arrange to pay the amount of gratuity within 30 days from the date it becomes payable. Under subsection 3A of Section 7, if the amount of gratuity is not paid by the employer within the specified period in subsection 3, that is 30 days, Lordship, he shall pay from the date on which the gratuity becomes payable to the date on which it is paid, simple interest at such rate not exceeding the rate notified by the central government from time to time for repayment of long-term deposit, provided that no such interest shall be paid.
Your gratuity has not been paid till now.
No, Lordship. Gratuity paid, Lordship. Gratuity
That
paid
has been withheld because of
this year,
Rule
Lordship.
64.
No, but then has it till now? No, you said that regular pension is being.
And it's paid, Your Lordship. He will be getting, Your Lordship. We have issued the
Then
necessary
what about the
order.
gratuity?
Your Lordship, that will also follow. That will also follow. That will also follow, Your Lordship, because these are retirement benefits.
Gratuity we got this year, Lordship. They have, because there is an order June of this year saying that we have released. There is an order. They have, I think,
You have received already gratuity.
gratuity.
So when have you received it?
That is why they have issued some order June this year, Lordship. It is on record, Lordship.
So you do not know when you have received.
My Lord, there was a process, Lordship, and pension will get today, Lordship. Pension will get today, Lordship.
That is all right. Pension will get today.
Now,
You see, without knowing the exact date when you are getting pension and all.
my instruction that pension I'll get today, Lordship. I am yet to get, but I'll get today pension. But so far as gratuity, there was some technical problem, Lordship. So last week also I have contact with regard to the pension. So today also I called him. He said that we'll get today.
Gratuity, what technical problem?
Pardon?
What is the technical problem with gratuity?
From the Treasury, Lordship. Now it can be, since government has given some letters, Lordship.
See, if you want to attribute fault on the government, then you must be knowing those dates and all.
Lordship, then Lordship, from long, provided the
Without that, how, on what basis your claim for interest will?
then I'll communicate, Lordship, that one. Exact date when I have received the gratuity and leave salary, Lordship.
When can you give it?
Bye. Or Lordship can pass from the date of the
We will not
order.
pass on, if at all you are.
Or I'll provide the date on which he.
If you have a claim for interest, then you have to give us the date and all. Otherwise,
I'll provide.
this court will not determine. Hmm?
Because they have issued the letter, Lordship, 4th of July, Lordship. And one is 4th of July regarding pension, and one is for June 26. They have, this is the release order issued by the government. I'll try to find out the exact date when he has received the gratuity, Lordship.
No, the date of release by the government.
Yes, Lordship. I can provide date of tomorrow I can also tell the communication. Here, Lordship, this judgment says that this is a mandatory provision, Lordship. That para 7. Married, Lordship. Married para 7, Lordship. It's not complete.
You were reading para 7, I
Not
think.
completed, Lordship. The interpretation. Middle of the para have reached, Lordship, after that. From the provision made in section 7, a clear command can be seen mandating that the employer to pay the gratuity within the specified time and to pay interest on the delayed payment of gratuity. No discretion is available to exempt or relieve the employer from payment of gratuity with or without interest as the case may be. However, under the proviso to section 7A, no interest shall be payable if the delay in payment of gratuity is due to the fault of the employee, and further condition that the employer has obtained permission in writing from the controlling authority for the delay payment on the ground. Under section 8, provision is made for recovery of gratuity under the Act if not paid by the employer within the prescribed time. The collector shall recover the amount of gratuity with compound interest thereon as area of land revenue and pay the same to the person entitled. A penal provision is also made in section 9 for non-payment of gratuity. Payment of gratuity with or without interest as the case may be does not lie in the domain of discretion, but it is the statutory compulsion. Specific benefits expressly given in a beneficial legislation cannot be ordinarily denied. Employees on retirement have valuable rights to get gratuity, and any culpable delay in payment of gratuity must be visited with the penalty of payment of interest. Was the view taken in case of State of Kerala versus M. Padna Namban Nair? Earlier, there was no provision for payment of gratuity on the delay payment of gratuity. Subsection 3A was added in section 3 by an amendment which came into force with effect from so-and-so in the case of so-and-so. Lordship, what my friend, he got the instruction that till now gratuity also he has not received, Lordship.
Because of the government's fault?
Yes, Lordship.
You said they have issued release order. Then?
The release order, Lordship, June this year.
Then what is the reason of non-receipt of the same?
Maybe some problem with the treasury, Lordship.
No, I don't. He has to. I think he has to present himself personally, physically before the registry officer.
We'll get. You cannot blame the department
for that life certificate. If I'm not,
I am not blaming for department from June to till, Lordship, but they have issued the order till June this year, Lordship. 3 months is okay, no problem. Maybe my fault. I can. That is my submission.
And then when this order for release of pension has been issued, regular pension?
That is, Lordship.
That is also June 23?
Yes, Lordship.
So why you have not received pension also till now?
So gratuity order, Lordship, 28 June 2023. Then, Lordship, So leave encashment order 4 July 2023.
Leave encashment, not leave encashment. We're talking about gratuity and all. These are not good things. If you have information, you give it. If you do not have it, just say you do not have.
Lordship, as of today, we have not received, Lordship.
Yeah, we'll reserve.
Lordship.
Hello.
Yes.
Item number 12.
Hello.
Yes.
I mean, led by
Yes, sir. Please.
May we please, Your Lordship?
Yes, yes. Yes, please.
I'm appearing for the petitioner in the present case.
Yes.
Wherein the first information report dated 14/4/2023 is impugned. My Lord. We are seeking quashing of this FIR. But before I take your Lordship to the first information report dated 14/4/2023, on the basis of which Jawai PS case number 4804 is Infosys in bracket of 2022.
You are also appearing here.
Was registered.
We are led by.
Yes, yes, please.
Now, I'll just give the brief background of this case. My Lord, may I ask, I'm sorry, my Lord, there are some miscellaneous cases, and we have filed our reply.
May it please your Lordship. Lordship, in fact, we have filed a miscellaneous application. That is this application number.
By the state.
Yes, Your Lordship. 73 of 2023, Your Lordship.
What is that about, Mr. Shah?
Lordship, because what happened, there was an interim order passed by this honorable court, Your Lordship. Your Lordship will find it at page 12 of that.
73?
Page 12 of that miscase.
Oh, yes. There's an interim order passed.
Your Lordship, yes.
Yes, where is it?
Lordship will find it at page the operative part at page 13.
Yes.
Lordship has got it. Upon hearing the submission, Lordship has got it.
Yes, yes.
Upon hearing the submission of the learned senior counsel for the petitioner, this court will not go into the merit of the submission at this point of time. Suffice it to say, on the assurance given by the petitioner that the petitioner company through its director official will cooperate with the investigation, we will continue. Therefore, until further order, no observation be taken against the director official of the said company. Your Lordship, taking advantage of this no coercive action, Your Lordship, what happened? These people, Your Lordship, they accuse here, Your Lordship, they refuse to cooperate with the its investigating agency, Your Lordship. That is why we are compelled to approach this honorable court for a modification or recalling of this order.
Now,
they are not cooperating,
now
Your
if that matter is finally taken up,
Lordship?
Yes.
If this matter is taken up for
Lordship,
final
then,
hearing,
then
is
yes,
there any use?
Yes, Your Lordship. If the matter is taken up for final hearing, yes, Your Lord.
I think. So we can proceed with the hearing, I think.
Lordship, yes, let the petitioner start, Your Lordship.
Yes.
All right. My Lord, I was submitting that before I proceed and before I place the first information report that has been impugned before Your Lord, I just want to give some background a contract was awarded to the petitioner, Jindal India Limited. It's a reputed multi-million crore firm. The contract was awarded by the state of Meghalaya PHA department for supply, delivery and stacking of the GI pipes of given specification in different depots. Depots were also specified, the place where it was to be delivered was specified in the contract. We, from our factory, made these pipes and delivered to the transporters. The transporters received it and they loaded in their truck and proceeded towards Meghalaya. Thereafter, we submitted our invoice for the consignment that was supplied, and we were surprised to know, rather informed, that these materials did not reach the PHA department. The places that were designated, it did not reach. And then, we checked up the copy of the invoice, which was returned to us, and we find that this was not properly received. Thereafter, we inquired and we came to know from the respondent only that on the instruction of marketing manager, who is accused number 9 in our FIR, is not a party here, he, along with my lord, in connivance with the
there is any other FIR? How many FIR there?
There is one FIR.
No, my lord, this is a counter FIR which has been filed. The first information was lodged by us in West Bengal, in Sankrail police. That's why I'm trying to give the lordship the background. Because the background in which this FIR has been filed, it will be necessary. May I proceed?
Yes, yes. This court is trying to, in fact, get the facts. See, like
that's right. That's why I'm
please.
taking your lordship through the background. Otherwise, I could have straightway come to the FIR. Now, we came to know that the marketing manager of the petitioner, in connivance with the informant of this particular FIR, which is impugned before your lordship, and others, the transporters, they connived together and then, my lord, they misappropriated the entire consignment of GI pipes. There was misappropriation. As a result of which, the petitioner lodged a first information report before Sankrail police station in the West Bengal. Now, we have to go, my lord, to the CGM Howrah, who directed an FIR to be registered under section 156(3) of the code to the OC Sankrail police station, and accordingly, this your lordship may know, Sankrail police station case number 1144 of 2022 was registered against the present informant and others under section 120B, 419, 420, 467, 468, 470, 71 and 409. Your lordship knows 409 is an offence punishable up to life imprisonment. I will place that FIR also. Now, after we file this FIR, the informant, who is respondent number 2 in the present quashing application, he filed a quashing petition before the Calcutta High Court. And the Calcutta High Court, by its order dated 12th of April 2023, quashed the FIR, which was filed by us. We, my lord, approached the Supreme Court. And the Honorable Supreme Court, by its order dated 18/5/2023.
Those papers. Where can I get those orders? Those copies of the orders you are referring to.
I will just refer this. I'm just giving you the background.
Yes.
I will place everything, my lord.
Yes.
Then the Supreme Court, my lord, by order dated 18/5/2023, set aside the Calcutta High Court, and the matter is now pending investigation before Sankrail Police Station. Now, at that stage, the present FIR was filed. I will place now the FIR that we have lodged before the Sankrail police station. That, my lord, your lordship will kindly take the criminal petition number 69 of 2023, the present petition. Your lordship will kindly come to page 23. 23.
Yes.
Your lordship may come straight to paragraph 5 at page 26. Your lordship got it?
Yes, yes.
I'm placing paragraph 5 as page 26. In March 2021, the complainant petitioner was declared successful bidder for supply, delivery and staking of ISI marked medium quantity GI pipe for water supply scheme under DAMM to Public Health Engineering Department, Government of Meghalaya POG, and various supply orders were issued to us. The details of supply orders are as follows. Then my lord will come to the next page, paragraph 6. The total value for the sum of the total order value was for a sum of rupees 136.65 crores approximately. The term of the contract with PHE was that the complainant and petitioner will supply approximately 17,393 metric ton of pipes over a period of 8 to 10 months to various designated depots owned or controlled by Public Health and Engineering Department, Government of Meghalaya, Office of the Chief Engineer, PHE Meghalaya, Shillong. Now, my lord will kindly come to page 42, because these are the different orders which are given. I need not waste your lordship's time. The lordship can come to page 43. Paragraph 13, page 43.
Yes.
As and when the materials have been dispatched from your petitioner's manufacturing unit, corresponding invoices were issued on PHE. However, payments were withheld till about April 2022. In April 2022, PHED informed that they were unable to make any payments whatsoever because they have not received the majority of the materials. More particularly, the materials mentioned in the above table entrusted to the accused persons 1 to 3 pertaining only to Jawai division. On the contrary, they clearly refused to make any payment unless the aforesaid goods were supplied to them. 14. That your petitioner was completely shocked and surprised to receive the letter from PHED. Your petitioner immediately consulted the record and pulled out all the relevant consignment notes, lorry challans, relating to the consignment that were allegedly not received by PHE that had been returned by the accused persons with the endorsement of the recipient. The petitioner was aghast to note that none of the said consignment or lorry challans before the stamped signature of the authorized representative of PHED. On the contrary, some of those were unsigned and unstamped, while others have some scribbles or illegible signatures. In the light of such evidence, all the representatives of the accused persons, accused number 4 to 7, were called and confronted them with the letters received from PHED and aforesaid consignment. Lorry channels were also supplied by the respective accused persons. After much persuasion, they, accused 4 to 6, confessed that they have handed over lorry challans along with the materials to various persons other than specified destination of PHED as per direction of the accused number 7 and 8. Accused number 7 is the informant, my lord, and respondent number 2 in this petition.
Accused number 7.
And 7. He is respondent number 2 and he is the informant in the impugn FIR. And 8 is his brother, who is not a party here. As they were very close to then management of the company who were at the helms of affair till August 2021. Name of the accused person number 9, the then marketing head of the complainant, petitioner also came up during the discussion as being the person who were instrumental in issuing such direction to the accused persons regarding the place of delivery of the materials. They confessed that they had instructions from the accused persons number 9, and they were all called, they were to call accused person number 7 and 8 as soon as they cross into Meghalaya, and that they were to deliver the entrusted goods at a place as per their instructions. These were the destinations different from the ones designated in the lorry challans. The accused persons have confirmed such a statement in email sent to your petitioner. The copy is enclosed. I'll not take your lordships through this. Now, this FIR was challenged, my lord, by them, as I have stated earlier, and I'll take your lordships through the Calcutta High Court, my lord, by its order dated 12/4/2023, quashed this at page 100, my lord, will get. At page 100. This order dated 12/4/2023, Annexure 7. I not got it.
Yes, page 100. Yes.
If your lordship can come to the operative portion at page 105, straightway. I'll not take your lordships through the entire thing. Ultimately, this was set aside. So at page number 105, if my lord will kindly see.
Yes.
Accordingly, further proceeding in GR case number so-and-so arising out of Sankrail Police Station 1144 of 2022. This is the FIR case number. Dated so-and-so under section so-and-so be quashed. So this was quashed.
Yes.
Then my lord will kindly come to the order of the next annexure is in respect of his brother, my lord, who is not a party here. Now your lordship will come to page 1114, annexure 9. There is an order by the Supreme Court dated 18th of May 2023.
Yes.
Now, my lord, we will kindly turn to page 115. 115.
Yes.
The last paragraph. On going through the materials disclosed, we do not think that at the stage of investigation itself, the High Court could have come to a definite conclusion that the dispute between the parties were essentially civil in nature. At least the nature of the complaint reveals certain ingredients of criminality which are required to be tested in course of proceeding stipulated in the court itself. The law enforcement agency, on conclusion of the investigation, chose to submit charge sheet containing certain questions that ought to have been examined at the stage of framing of charge. Siddharth Luthra, so-and-so, learned senior counsel appearing on, Siddharth Luthra, learned senior counsel, has submitted that books have been delivered. But this is disputed by Mukul Rohtagi and so-and-so, learned senior counsel appearing to the appellant. This being the position, we set aside the impugn order, but at the same time direct that the respondents ought not to be arrested till the stage of taking cognizance. So there is a protection for them. We are passing this protective order having considered the state submission that the two respondents are cooperating with the investigation. Mr. So-and-so assures that his clients will cooperate with the investigation. Whatever observation we have made in these are, of course, will not affect the process. So this was set aside and the investigation is on as I have submitted. Now at this point of time, my lord, the impugn FIR is lost. And I'll pick your lordship through the impugn FIR. Your lordship will kindly come to page 18, annexure 2. Well, before I take your lordship through this FIR Annexure 2 at page 18, your lordship will find there has been repeated reference of the FIR of Sangrail police station in this FIR. I'll please. This is addressed to officer in charge of Hawaii Police Station, Meghalaya. I was appointed as authorized commission agent by Jindal India to represent him in PHE, Meghalaya, for getting materials cleared at consignment end and to get the payment released to Jindal India Limited bank account from PHE at an early date. Our authorization certificate was signed and executed by the employee of Jindal, Sri Ravi Suga, so and so. I was also trading in pipes and sheets manufactured by Jindal on the basis up to 2021. In 2021, I have paid Jindal India an amount of rupees 1 crore 12 lakhs 60,393 for purpose of materials, after which they denied to give the materials and also denied to refund the money, following which I raised my matter with the NCLT on 17 September 2022, along with interest amounting to so-and-so, totaling so-and-so. Following which, Jindal India has filed an FIR in Howrah, West Bengal, wide FIR number, this is Sangrail PS case number 1144/2022, alleging that a few consignment of GI pipes sent to PHE Jawai division mainly have been diverted on the instruction of myself and my brother Umang Dandhania to other places by transporters of Jindal and Company, has incurred financial loss of 16.79 crores approximately. Annexure of the said missing transport LR along with the corresponding truck number is attached as Annexure D for ease in tracing the truck in PHE records. Period mentioned by Jindal for missing trucks are from March 2021 to May 2022. Jindal took shield of this FIR in NCLT case to deny money to me. A copy of their NCLT reply affidavit is attached herewith. Jindal has sent me copy of the FIR filed along with various supporting documents by email dated 15/2/2023 through its advocate on record, Shri Subhasis De, for above stated NCLT case filed by me, Ayush Dandhania, on Jindal for recovery of 1 crore 31 lakhs 39,182. I was shocked to see the supporting documents given by Jindal along with FIR, as many documents were prima facie contradictory in nature and forced by Jindal for the benefit of its case 1144/2022. If your lordship's permission, may I pause here for a second and submit. They are questioning the veracity of the documents submitted along with the FIR filed in Sangrail Police Station, Calcutta, in this paragraph. Then I please file. Jindal has annexed a document signed by one Ramesh Bansal as director on a letter dated 25/2021 to Chief Engineer PHE Meghalaya, which is a forged document. I will kindly mark it, which is a forged document, as Shri Ramesh Bansal has commenced as director only on 27/8/2021. This letter is on record. A copy of the Ministry Corporation Affair confirmation is also attached herewith. This letter is further countersigned and verified as true copy by Mr. Sudipto Bhawal on behalf of Jindal India Limited. Both Ramesh Bansal and Sudip Bhawal are aware of the untrue fact and has knowingly forged document and submitted the same to police and honorable court in the West Bengal. Your Lordship, kindly mark it. It was submitted to the police and honorable court in the West Bengal. Our lawyer, made an RTI to PHE for confirming the receipt of the letter by them, and they clearly denied ever receiving such letter. I'll place this letter later on. Mr. Biplav Sharma, employee of Jindal India, was responsible in 2021 for third-party inspection before the dispatch of materials from factory of Jindal in West Bengal, presently representing in PHE Meghalaya, is hiding the fact that rupees 16.79 crores pre-inspected materials have already been delivered to PHE from the said missing materials, and the payments has also been received by Jindal in its official bank account for many of the alleged missing consignments. Despite receiving the payments from PHE, they have made criminal conspiracy against me for falsely accusing me in the theft of 16.79 crores. May I, my lord, I just want to, because I don't have to come back again. I just want to say what they're saying is that we have received the payment, and knowingly that the payments have been received, we are accusing them of stealing by filing this present FIR.
That is a kind of defense. It's a kind of defense against the FIR filed in Calcutta.
My lord?
It's their defense against the allegation made in the FIR in Calcutta.
Absolutely. Your Lordship has rightly got it. Since the Jindal was aware of the actual delivery location of the missing trucks, they have paid many freights of the alleged missing truck to the said transporter even up to 2022. But despite making freight payments and transport to transporters, chose to file this misleading FIR. I further came across 3 different emails issued to Jindal by its transporter, namely Raj Carriers. They are Srinivas Roadways Private Limited and Roadways Transshippers of India. They are all accused, my lord, in this, which are highly contradictory in nature. The emails state that Ayush Jatia was director, whereas Ayush Jatia has ceased to be director of Jindal in India Limited since 1/8/2018. The email of Srinivas Roadways clearly states that materials have been directly unloaded by truck drivers at different PHE depot. Most of the time, receipt, signed challan were delivered and signed and stamped by PHE officials while delivery, and only in few cases Ayush Dandania has signed the LR himself. Whereas email of Raj Carrier contradicts emails, they are not very relevant still. Whereas email of Raj Carrier contradicts the email of Srinivas Roadways and states that Ayush Dandania used to instruct for delivery of the materials at different depot, and Ayush Dandania used to take the invoice at the time of vehicles reaching the unloading points and take responsibility for unloading. Email of Transshippers of India further contradicts the email of both Srinivasan Roadways and Raj Carrier and states that Ayush Dandania and Umang Dandania used to instruct for delivery of materials and receiving was also arranged by them. Whereas the fact is that the materials were directly unloaded by the transporter of Jindal's at PHE depot as instructed by Jindal in third-party inspection report of Dr. So-and-so, so-and-so. A copy of the PHE reconfirmation of few of the alleged missing consignment is also attached here with as a proof of delivery to various division of PHE. Jindal is trying to threaten us through their West Bengal FIR 1144 of 2022 that if we did not take back NCLT case against them, then they will get us falsely implicated in West Bengal FIR. They will also deny all the authorization given to us and straightway deny all our doings in PHE Meghalaya and get us behind the bar. My marriage ceremony was scheduled on 1/2/2023 in Kolkata, which got cancelled due to filing of this untrue case by Jindal FIR 1144/2022. I pray to Meghalaya Police to kindly register an FIR in the said matter as early as possible and begin investigation of the forged documents and misleading facts given by Jindal. I shall be thankful rest of my life to Meghalaya Police for investigating the same in Meghalaya, as alleged place of occurrence is Meghalaya, is Jawai, Meghalaya, and it shall be in the interest of the case if the matter is investigated here in Meghalaya. Now, if my lord will see the sum and substance of the contents of the FIR that I placed before your lordship is that the petitioners have filed a false first information report before Sankrail Police Station, West Bengal, and they have also annexed forged documents before the police and the courts in West Bengal. Now, I asked a question to myself. Who will decide, my lord, and this is a question to myself, who will decide whether the FIR lodged by Jindal is a false FIR, whether the documents annexed with the FIR are forged documents? Who will decide? Now, the answer is obvious. It will be decided by the courts in West Bengal. And they can go and take the defense. Why filing this? Filing of this FIR is nothing but an abuse of process of the court. And my lord, assuming for a second that this FIR is incorrect, false, they have remedy, because the court which will try this case has the power to direct registration of case under section 211 for filing false information to the public officer. If the court can do it. But they chose to file it in Meghalaya. It's an FIR which basically says that the petitioner's FIR is false, the documents are forged, therefore you take action. In my humble submission, my lord, this FIR cannot stand the scrutiny of law. Your lordship will rise for the lunch.
Well, we'll continue after the lunch break.
Yes. And your lordship says that, with your lordship.
Sit at 2 again.
Up to
Before my lord starts with the matter, if I may be permitted to mention one matter, my lord. Item number 13, lordship. 13, lordship. 13. May this matter come, my lord, after puja, lordship. I've already informed the other council, lordship. Yes, lordship. I've informed.
Yes, sir.
My lord, pre-lunch, my lord, I placed both the FIRs, one which filed by us, Calcutta, and the other which have been filed by them before Jawai police station, raising the question that the FIR filed by us in Calcutta, in Sankrel police station, West Bengal, is false, and it is based on forged document that has been annexed along with our FIR. And then I also, my lord, posed a question to myself as to who is going to decide whether the FIR is false or the documents annexed with the FIR are false. So I have read. Now, my lord, I will place the provisions under which provisions of Indian people.
You were saying something about the FIR in Calcutta, that in the event that FIR is proved to be false one, then there is some remedy available.
Yes. Your Lordship will kindly take 195, section 195 of the code. 195 of the Criminal Procedure Code. I'll be referring 195 1B1. No court shall take cognizance of any offence punishable under any of the following provision, any of the following section of Indian Penal Code, namely 193 to 196, 199, 200, 205 to 211, and 228, when such offence is alleged to have been committed in or in relation to or in any proceeding in any court. So this 211, if your Lordship will see, IPC, Indian Penal Code 211.
Falsely charged.
$211, my lord. Look.
Yes.
False charge of offence made with intent to injure. Whoever with intent to cause injury to any person instituted any criminal proceeding against that person or falsely charges any person with such proceeding falsely charges any person with having committed an offence knowing that there is no just or lawful ground for such proceeding or charge against that person shall be punished with imprisonment of either description, which may extend to 2 years, or with fine or with both. And this, if it is discovered during the inquiry or trial that it is false, then the court itself will lodge the FIR under 340 of the CRPC. There is a provision under 340
yes,
for perjury as well as for making false complaint.
Yes.
Now, yes. Lord, I come straight to the provisions under which the case of in Java police is registered against the petitioner. My Lord, there are 3 sections. 120B, Your Lordship just write somewhere. 120B, Section 34 and Section 469 of the Indian Penal Code. I'll first place, my lord, Section 34 before your lordship. 34 of IPC.
Yes.
Acts done by several persons in furtherance of common intent. When a criminal act is done by several persons in furtherance of the common intention of all, each of such person is liable for that act in the same manner as if it were done by him alone. This is 34 IPC. Then I'll take your lordships to 120B. 120B. Lordship must be dealing with 120B every day.
Yes, Yes, please.
Punishment of criminal conspiracy. Whoever is a party to a criminal conspiracy to commit an offence punishable with death, imprisonment for life, or rigorous imprisonment for a term of 2 years or upward, where no express provision is made in this code for punishment of such conspiracy, be punished in the same manner as if he had abated such offence. 120B2 says, whoever is a party to a criminal conspiracy other than a criminal conspiracy to commit an offence punishable as aforesaid shall be punished with imprisonment of either description for a term not exceeding 6 months, or with fine, or with both. Now, my lord, I pause here for a moment and submit before your lordship. Both these sections refers to criminal act. Now I ask a question to myself, whether approaching lawful authority by filing a first information report can be said to be a criminal act by any stretch of reasonings. Because I have gone to the police, I have filed an FIR that they have misappropriated the materials with which they were entrusted, and the same were not delivered. This is not a criminal act by any stretch, my lord. Then, my lord, I'll take you. Therefore, my lord, both sections, section 34 and 120B, ruled out in the present case. Now I'll take your lordships to section 469. This is the last section which has been mentioned in the first information report. 469. Got it?
Yes. Please.
Forgery for purpose of cheating. Whoever commits forgery intending that the document or electronic record forged shall be used for the purpose of cheating. I think this is, I'm sorry, I read 468. 469. Yes. Forgery for the purpose of harming reputation. Whoever commits forgery shall, intending that the document or electronic record forged shall harm reputation of any party, or knowing that it is likely to be used for that purpose, shall be punished with imprisonment of either descriptions for a term which may extend to 3 years, and shall also be liable to fine. This is the section with which I have been charged, or is, my lord, registered against me. This is a cognizable and a bailable offence. 469. Punishment is 3 years. Now, my lord, what is the document that they are saying that has been forced, which has harmed their reputation? My lord, I'm sorry, my lord, I have to take your lordships again to the first information report, and then I'll take your lordships to the document. My Lord will kindly come to page 18. The charge sheet is the first information report, includes first information report. I'll read again paragraph 5. My Lord, I'm sorry at the cost of repetition.
No, it's all right. Carry on, please.
All right. I'm placing 5. Jindal has annexed a document signed by one Ramesh Bansal as director on a letter dated 25/2021 to Chief Engineer, which is a forced document. As Shri Ramesh Bansal has commenced as director on 27/8/2021, this they are saying from copy of the Ministry of Corporate Affairs, where it is written. The letter is further countersigned and verified as true copy by Mr. Sudeep Bhowal on behalf of Jindal India. Both Ramesh Bansal and Sudeep Bhowal are aware of untrue acts. Untrue acts means he is not a director, Ramesh Bansal, and has knowingly forged a document and submit the same to police and honorable court in West Bengal. Our lawyer made RTI to PHE for confirming the receipt of the letter by them, and they clearly denied ever receiving such a letter. Now, this letter is annexed in a affidavit in opposition filed by the respondent number 2, an informant, on 24/7/2023. My Lord,
Where is that? Which page?
It's an affidavit AO dated 4/7/2023.
What is the page? Exact page you were referring to?
Mr.
Page 15.
Page code.
Dr. Majid, yes. What page? Page 15. 15.
Sitting like that. I'm sorry, my lord, I have only internal page. In fact, I was engaged only on Saturday. Where we have sat. Your lordship got it.
Page 15. Page 16, the FIR, Dr. Mujiga. That is of the Howrah.
Affidavit in opposition dated 24/7.
We'll get thinner one. Affidavit in opposition filed by one of the respondent number 2.
No, it's all right. I will find it out. Yes. That is communication dated 25/2021.
This is at page 15, internal page 15 of the
Annexure 3, yes.
Yes, my lord. Yes. Now, unprint this. This is addressed to Chief Engineer PHE Meghalaya Shillong relating to supply delivery so-and-so. This is in reference to above referred 3 supply orders issued by PHE to Jindal India Limited, its written JIN, wherein supplies of GI pipes are ongoing. We right here need to kindly inform you that due to sudden outbreak of COVID-19 situation, which continues till date, our production and supply planning activities took sharp hit and got severely affected, which among other factors largely stemmed from resulting consequences of pandemic, like increased COVID positive case in factory premises, acute shortage of manpower, labor, machine, raw materials, input resources, etc. There are also various restrictive notifications issued by the competent authority which are adding up to the cause by forcing plant to run in control and capacity, and as such deferring the production schedule. Needless to assert that despite our best effort, the above situation resulting in delay and execution and delivery of the material under the above referred 3 supply orders issued by PHE. Accordingly, in view of the above extraordinary circumstances, which are beyond our control, we request PHE to kindly extend the time for completion of supply delivery under so and so. Besides above, we also humbly request you to kindly consider releasing the payment pending against supply orders already made as under so and so, so and so. Now this, they say that this is signed by Ramesh Bandal, who is not a director. But I asked a question again. In what way this is harming the reputation of the informant? Because 469, they say it is force, and 469 is for harming reputation. Does this letter harm the reputation? In my humble submission, my lord, no. This is a correspondent which is explaining the delay at that point of time, that due to COVID we are unable to promptly supply the materials. That is what it contains. Now in paragraph 5, your lordship has seen, there is a forged and fabricated document submitted to the West Bengal police and the West Bengal court. My lord, in my humble submission, below, there is absolutely no case is made out by the FIR. It only talks about the first information report filed by the petitioner in Calcutta, which they say it is based on forged and
it's a kind of statement of defense.
Yes, they can take that defense anything. Oh my lord, suppose, for example, my lord, let me say, your lordships are aware, there was first case wherein it was said that 2 FIRs on the same facts cannot be lodged. That was T.T. Anthony's case, my lord. The judgment was by Justice K.T. Thomas. That was explained that if anybody has any counter case, it has to be filed before the same investigating officer, same investigating authority. It cannot, if at all they have a counter case, they don't have. But if at all they have a counter case, they will have to go and file there, which will be their defense. Both will be investigated together. So in my humble submission, there is absolutely, the FIR does not make out a case for the police to register, and it is nothing but abuse of process of the court. And my lord, the last but not the least, your lordship has seen the application for vacation or modification of your lordship's order, wherein your lordship has said that no coercive action to be taken. My lord, kindly see 469 is a section which is bailable. 469 CRPC, your lordship will see the...
Yes, okay. So you do not have to see, it's all right. Your submission is okay, yes.
Yes, it's a bailable offence. What coercive action they can take against us? If some document we are not giving under 91, or they apprehend that we will not give document, they can always seize those documents. What, they will arrest us. But they are calling directors to the police station. They are harassing by all means on this, my lord, trump up FIR, which has absolutely no basis. Therefore, my lord, in my humble submission, there is absolutely, my lord, no case made out, and the FIR, my lord, may be caused for the ends of justice. My lord, I have completed my argument. I am grateful, your lordship heard. May I, my lord, request that I may be permitted to leave the court. My friend Mr. Nitish Mutka is there. He will note down, and if required, my lord, if your lordship so desire, I can come back and address on the argument that will be advanced by learned friends from the opposite party. On 11th, my lord, 10th, tomorrow I am a little busy in the court. Day after, my lord, I am prepared.
Yes, in the event, in the event some reply is needed, then only we'll call.
Yes, that's right. That's
I would be happier if my senior colleague of mine, Mr. Mishra, would have heard my argument with regard to his argument, my reply to that. It would have been an opportunity for me also. But anyway, he maybe have other.
You see, they were on the lighter side, I will say, well, there were two poets. So one poet, he said, he listened to my poem. So he says, okay. Then he listened to his poem. When his turn came, the other fellow ran away.
So I am here to stay, not to run away.
These are all the lighter vein. Otherwise, my lord, my learned friend is my lord. He's a very well known lawyer. My lord. I have all respect for him. He is my younger brother. My lord, your lordship kindly permit me to leave the court. And I'll
Yes.
I'm all right.
My lord, at the inception itself, my lord, I'll start from the point wherein...
State will not reply first, so you will reply.
No, I'll reply first, then the CDN also.
State has come up with a miscase for vacating the interim order.
No, that will be a separate issue. If the whole case goes on, there is no point of continuing with coercion orders. That I will satisfy this court. Now, coming into this, my argument, I'll start from where this honorable court made an observation to the extent that it's a defense case. Now, my lord, in a given situations, my lord will kindly note down and bring it before the investigating authority with regard to the fact that B lodged an FIR against A, counter FIR, stating that A, while trying to commit murder of me, accidentally, she was, the bullet hit C and he expired, and this is the case. Both FIR is required to be registered under the law. When an FIR has been given, whether it is cognizable, it is non-cognizable, that's a different issue. First point of time, an FIR has been lodged, it has to be registered. Now, my lord, here is a case wherein, my lord, this case has been projected by my knowledge senior colleague. It's been the half-truth. And my lord, half-truth is very dangerous. My lord very well knows. Then they lodged an FIR in West Bengal, my lord, stating some facts with some documents. We challenged it in the court of law, sir, believing in the court of law. The Calcutta High Court, rightly or wrongly, come to a finding that this is a civil nature quashed. They have the right to appeal against that particular order. They avail their constitutional right. The division bench of the Honorable Supreme Court has been reflected in the order itself, my lord. I will not read it and waste the valuable time of the court. What is the order? Initial stage of investigation. And as such, the order has been interfered with, giving the respondent the liberty to come again before the appropriate forum. I will read the order, my lord. Reading the lines between the order will not help, my lord. Giving them, my lord, the last paragraph will kindly see, even I can come for quashing before this honorable court. That is the last 1106, page number 116 of their criminal petition, my lord. Whatever the observation we made in this order, the same are based on the stage at which the quashing orders were passed, initial stage of investigation. And we are not foreclosing the options of the respondent, ours, to approach the appropriate format at any subsequent stage for seeking relief if advised. Am I clear?
That is in respect to their FIR.
Their FIR.
No, filing a counter FIR.
I'll come to that, my lord. I'll try to satisfy with my limited knowledge, my lord, my vast knowledge dealing with every...
Don't mind, this court has the habit of asking questions. That is what...
Yes, that's very thing that makes the clarity with regard to the thought process. And I appreciate that, my lord. That is forthcoming before this honorable court. Now, the whole of this case with regard to this was of 2022, the Calcutta FIR. Now it is 2023. Now the quashing order, my lord, will kindly see the date of order. That has been on May 2022. At appropriate stage with regard to the allegation that has been leveled against it, we have been given the liberty by the Supreme Court itself to go to the appropriate forum at the appropriate time as advised. And we may come for quashing of that particular FIR on the basis of factual metrics arising out of investigation in this case. What is this case, sir? Simply that this informant of the instant case lost an FIR before here. He's been a resident out here. He lost an FIR out here. My lord, the FIR has been lost only on the basis that the goods has been transported to Meghalaya and misappropriated at Meghalaya. As because my lord very well knows with regard to that famous Mazetia's case, wherein a truck went from Meghalaya to Mumbai, and then after misappropriation took place. So with regard to Mazitia's case, FIR was lodged in Meghalaya. It was refused to be quashed in the Bombay High Court. The matter went to the Supreme Court. As because it has been interfered with, because cause of action arises, 178(1), part of cause of action arises in Mumbai itself. So Mumbai have the jurisdiction. So that has been the law as on that. On that very basis, with regard to that, they have lost an FIR because part of cause of action, because the material has come from Kolkata. And with regard to that, Supreme Court judgment has been there, investigation is going on. Well and good. But what they have come in, my lord, I will pray before this honorable court, what they have presented is not the full truth. That FIR that has been lost by us with regard to, my lord, documentary evidence which we have got by of RTI, it's a special act, special legal central act for the purpose of transparency. Under the RTI Act, what document that has been given was beyond the imagination of this particular informant. False bills are signed. The signature appears of that of the informant. Money to the tune of 40 lakhs and above has been siphoned off. Taken payment on the basis of forged document. Where it has been submitted? Which document? This company's document. Where it has been submitted? In Meghalaya. And my lord, the irony part is this, and very shameful, sir, with all respect, that Learned Senior Counsel has submitted 340 provision. Yes, it's a different issue altogether. I'll answer that particular question. But the question out here, that the FIR is a defense case or not? Absolutely no. This is an independent FIR that has been lodged at Meghalaya because this company and its particular persons, my lord, submitted false documents showing the signature of the informant, which I have got in RTI reply. And the bill they have annexed herein in their writ petition, my lord, signature doesn't tally. These are not available with regard to the department, PhD department. These documents are not available. What available is my forged signature, which is not mine. Isn't it serious matter, my lord? Wherein the companies force my signature, submits bills and siphon of exchequer's money, my lord, taxpayers' money. Isn't a criminal distinct offence? What are the sections of law that has been registered? I'll come to later on. Whether this court, the investigating officer has the power to investigate or not. That is governed by chapter 12 and chapter 13 with regard to the court. Here is a case, has been projected, my lord, this criminal proceeding outrightly should be dismissed. Why? Because they approached the honorable court not with clean hands. My lord will kindly see the affair they have annexed. There are annexures where it's an incomplete petition they have put in before this honorable court, and they try to obtain an order from this honorable court. Recently in Guwahati High Court, an inquiry has been given that when an FIR has been submitted, complete FIR is to be there for quashing. And on that very basis, earlier, 2-3 years ago, they obtained a stay order with regard to investigation. Now, it has come to light to a particular bench, my lord, wherein knows the law, that where is this? And the other side has pointed out this is half-truth. And it was shocking, an inquiry has been given by Honorable High Court in a given situations. Here is a case, apparently they have annexed the FIR. Annexers are there, which are forged documents. And these are companies' documents. So, my lord, the investigating officer doesn't have the power to investigate it, sir.
No, argument was not this. See, the power has not been assailed yet.
Hi.
As far as the argument of senior counsel is concerned,
yes,
his submission basically is confined to the fact that the allegation which you have made in your FIR,
yes,
basically it comes as a reply to what allegation has been made in Calcutta.
Yes, that's what I started with the example. It's not a case that it is a second FIR. That is TT Anthony's rule back. There can be of two agreements.
So far as your FIR is concerned, basically it is not.
It's a defense case.
It is not based on any fresh cause of action. Basically, it's in relation to the investigation which has been initiated by the Calcutta police.
Absolutely no. There is no relation between the two. In a given situation, my lord, I will present.
But then you see the language your FIR. That is what you have used.
My lord, FIR, my lord, that I have written.
Saying that certain
Absolutely, my lord. FIR is just a phase. The body remains. Is the investigation and the document which has not been annexed. Is it a complete affair? Absolutely no. And if it is not complete, why my lord will invoke 482? Rarest of the rare, my lord. Exceptional circumstances. And the Supreme Court order goes against them. In that view of the principle, that initial stage of investigation, court will not interfere. It is my defense case, absolutely defense case. But my defense case is that they have lost an FIR before them on the basis of forged document. My FIR, what I have come to know, invoking my statutory right under the RTI, that my signature are forged on the very basis money has been paid by the department to the tune of lakhs of rupees. That is my case. And that are my annexes I am taking to your lordship. Now, that is my case. And it's an independent case, my lord. A police officer, my lord, suppose in a given circumstances, that a quarrel between husband and wife, my lord, 498A, he comes in, the investigating of it during investigation, finds some, my lord, weapons inside the thing. And where are the license? No. Won't be a case of arms act. My lord, narcotic drugs has been found. He doesn't have the investigation power with regard to this. He informed the customs officials. They comes in. Rouse in another affair. My lord, in a given case, in Tada cases, my lord, what happens? Tada, when it was in existence, my lord, police go, he is the member of the unlawful activities. That is a group which has been declared as unlawful, my lord, terrorist group under the UAPA. So Tada comes into. Now the police goes in and found search of him and found something incriminating so far arms is concerned. Another affair can be there. For the purpose of that particular Tada Act, he gets acquittal. But so far arms act is concerned, it's an independent, distinct proceedings, my lord. Wherein, for getting acquittal out here, he will not get acquittal, may not get acquittal there. Every case has to prove on its own facts. Even my lord will appreciate that. When there is an affair and a counter affair, and both ends in search sheet in a given situation, the law that has been laid down by the apex court, not been codified, that it should be tried by the same court. One may be of 302, a counter case is there with regard to the same affair, that may be of 323. But the sessions judge will be trying that 323 matter along with that and dispose of the matter simultaneously at the same time. That is the law of the land. Here is a case wherein my lord, this affair has been lost. I have stated in my affair with regard to the falsity with regard to their case. Is that a ground for invoking 482? Absolutely no. If I wouldn't have mentioned, that would have been suppression of material facts that I have mentioned. But what is the criminality that has been committed by them? Whether they have committed a criminal offence or not, that is the moot question. The document I got in, my lord, in the RTI reply, shows my signatures with regard to this. Every document. And these are not my signature, these are forged. And for that purpose, where they have submitted this document? Not in West Bengal. Where offence has been committed, my lord? The jurisdiction. Why I go to Calcutta? I am a resident of Meghalaya, my lord, proud citizen of Meghalaya. The offence has been committed at Meghalaya because they brought in this forged document, and whoever it is has to be found out during investigation. They have submitted this document to the department, and the department from Meghalaya has made the payment to their accounts. So forgery, what is forgery? There are two limbs of forgery, my lord. You can see. 463 is the definition. And after the Information Technology Act came into 1710-2000, that definition of forgery, my lord, with regard to document. So far document is concerned, the definition of document in the Indian Evidence Act Section 3 has been amended. Now electronic record is also a document, my lord. So for transferring of amount to their account, And that too on the basis of false, my lord, bills. It's misappropriation, my lord. It's criminal misappropriations, my lord, and that to taxpayers' money. Suppose in a given situation, my lord, Section 3 has been amended, now electronic records becomes evidence. These are the documents they have annexed in here in this petition. These documents they have bills, these documents they have annexed in. These are not available in the PHE. Now, what this honorable court will do in this particular facts? On the previous occasion, when I appear before this honorable court, I get ready with a 340 petition. Why? Because learned senior counsel has pointed out that when there are two things, my lord, with regard to certain provisions in the IPC which has become redundant, nobody use it. Lodging false affair itself is a criminal offence. 211, my lord, falsely charged, this one. But these are two different things, my lord. One committed during the proceeding of a court. One is outside the court. 195, 1B1 will come into only when it is in the proceeding of the court. And otherwise, this particular, my lord's, embargo that has been provided under 195, 1B1 will not be applicable. Now, whether they have committed, my lord, an offence in the proceeding with regard to this criminal proceeding or not. That is the question that has to be put it before this honorable court. I put it humbly before this honorable court. And my lord will appreciate the case diary. Now, these document, my lord, they have submitted at page, my lord will kindly come to. And mark it, my lord. These document at page 92 of this criminal petition. They have annexed. Is not available in the department. Archival 92, 86, my lord. 86, my lord. Is not available in the official record of PHE, and that is a matter of investigation, my lord, isn't it, my lord? And 86, 64, my lord.
3 pages, 92,
Yes,
86,
64 is the type copy, my lord. Salan. With regard to this, these are not available in official record. So what is a false document? I'll come and try to satisfy this honorable court. This may not be a forgery, but this is a false document. For what? For pecuniary gain or pecuniary loss. These are the three documents. They have annexed, and these are not part of, my lord, PHE. Whether this is a matter to be investigated or not. And I will pray before this honorable court with folded hands that my lord will pass an order, judicial order, asking the investigating officer whether these documents were available there or not. And whether the signatory of these documents were there. And if they say, my lord, I am not the person concerned investigating, I am saying that these are documents not available. They have gone to that extent of taking this court into that extent of committing a forgery by annexing a document, false document, to get an order, to which it will be amounting to a criminal distinct offence, committing in a proceeding of a court, and wherein this honorable court would be a complainant and direct the registry to register an affair independently of this. Another section, another criminal proceeding has to be initiated, because this has been committed in a proceeding of a court. Yes. Now my lord will kindly come to our affidavit, my lord. Yes. My lord will kindly come to our document, my lord, wherein I got these RTI documents, and on the basis of false document they have taken the bills. It's an independent distinct offence that has been committed here, my lord. At page 30. My lord, kindly see the signature appearing here appears to be of the informant, which is not the informant. That is my case. Page 30. Brother Ayush. Umang. His response number? Ah, okay. Anyway, this is a matter of investigation. So this is a matter of investigation at page 30, my lord.
This also you are saying false document.
This is a document that has been furnished to me under the RTI. On this basis, they have taken out amount of rupees 42,62,723.
That is also subject matter of investigation so far as...
Absolutely!
So that you are saying that this is also a false
document. Of course, this is not Ayush's signature. And Ayush during investigation has given his specimen signatures, my lord. And I'll come to my little length of argument that why, my lord, here is a case wherein custodial intervention may be necessary, may not be necessary, subject to my lord observations, my lord. And again, my lord will kindly come to at page 33. This is again a signature of another person, Umang, right? This is not Umang's signatures. This is again forced signature. That is my case. This is not the subject matter of investigation of Calcutta. This is a subject matter of investigation of, my lord, here. And the statement of witnesses has been recorded. And initial stage of investigations, my lord. Page 51 also, my lord. We'll kindly see. 51. This is again forced.
Of your affidavit.
Yes. This is my case. Why they have not annexed this document? Why? Because they have not come up with this honorable court with clean hands. This will be in the case diary, my lord. And that has been part with regard to this. And this is my case. Court could understand that. My lord will kindly come to page 67, 87 and 89 of their, no? Of their petition, my lord. 67, 87 and 89. 91, sorry. 91. These documents...
87, 91.
Yes, 64, 86...
87, 67, 87 and 91.
And 91. These documents are available in PHE record, but the signature appearing are false. And coming to my lord, I will be very precise with regard to my argument, my lord. A document that has been taken into, my lord, and pointed out with regard to at page 15 of my additional affidavit, that is Jindal India Limited, their document.
You have filed another additional affidavit apart from your...
No, that one that the learned senior counsel Mr. Mishra has pointed out and taken your lordship through this document. In additional affidavit of ours.
So means in addition to your affidavit in opposition, you have filed an additional affidavit also?
No, this is affidavit in opposition, my lord. My lord has once gone through this document. He has read it word by word.
Page?
Page 15, my lord. It should be there. I need to find out.
How many affidavits are there? This has been filed. This has been filed. This one number 1.
Always, if file correct, date to date.
Sir, you are representing respondent number?
I mean, 2. 2. My lord, page 15, my lord.
Respondent number 1. This is some affidavit.
State is there. Sulai Sahab is there.
Opposite party number 1, what is it? This case. This is in criminal miscase. This is in criminal miscase, not in the case.
Additional affidavit, my lord. Affidavit in opposition, my lord. It's been written, my lord.
Yes. You say additional affidavit, then.
I'm sorry. I'm very sorry.
You're referring to page?
Page 15, my lord. Before that, my lord, page 10, my lord, will kindly see. This is with regard to RTI. We got all this document and this forgery after RTI, my lord. And in Meghalaya, my lord. So we lost affair in Meghalaya. Why will go to Calcutta? 11, this is RTI informations, my lord, annexure 1, annexure 2, my lord, these are the documents that has been submitted to us under the RTI, my lord. Again, page 13, my lord, with regard to this. 14 and 15, my lord, they have this with regard to this. My lord will kindly see. This is a document dated 25/2021. My lord has raised this, that this is a document with regard 25/21. The question before this honorable court is that on that day, whether the person Ramesh Bansal, director, he is signed it as a director of Jindal India Limited, was a director? That is the question. If I am not the Prime Minister of India as on today, can I sign it as a Prime Minister of India? What is the authenticity of the document? That will be a false document. So 469 comes within false document. I'll come appreciate. There are other sections to be added, my lord, by the investigating officer.
But the section is not very relevant.
Absolutely correct, my lord.
At any stage.
Absolutely, at any time it can be put in, my lord. Absolutely correct. That is criminal investigation, my lord. That is criminal. I appreciate that, my lord. This document, they are admitting that 25/2021, he was not a director and he signed as a director of this. Whether it's a false document? The answer is yes. And if it is yes, then why not forgery? It's a false document. It comes within the definition of 463 of Indian Penal Code. And the rest of the documents I have already pointed out to this honorable court. What is this? Page 11, my lord, I can see. Yes, Amar Khan. Page 11, my lord, you can see the RTI reply, my lord. RTI reply. Had your office issued a letter to Jindal so-and-so, Priyat so-and-so, confirming any missing consignment of GFI which were to be delivered by the DMPH? No. The reply is no, executive engineer. Now, this document was created, my lord. Signing by a person who was not a director. Whether it amounts to a false document? Apparently, I am reading 463, not 469. These are sections of law. Anything can be added during investigation. A prayer has to be made to the. This is rudimentary, my lord. Now, with regard to my lord, a query has been made and submission has been made before his honorable court. Going to authority by lodging affair, is it a criminal act? Absolutely no. But I have a remedy under that particular law, that it is force, or this force or document has been submitted, or otherwise, when this cause of action will arise, when after investigation final report has been submitted, that nothing has been found, or otherwise search sheet has been submitted, and after the trial, if comes out it is to be force, and I am acquitted, I have a right to that particular law, that force document has been submitted, FIR has been lodged by vindictive measure, and these all will come under 340. When it comes to the proceeding of the court, not now. This is not the stage. Because every FIR lodging and thereafter 340 comes in, would very defeat the very objective of the provision of CRPC. Am I clear on that, my lord?
So 195, 340 is not applicable at this stage.
Actual investigation is going on. Nobody is true, nobody is false. They are saying in your quashing petition, my allegation is untrue. You come and give your specimen writings. Is it matched? Let it be sent to the FSL. And when the report comes in from the FSL, that these are not the signature of so-and-so and so-and-so. These are false. They are not denying the contents of these particular documents because they cannot. Because on that very basis, no, FSL report is there or not, it is preliminary stage of investigation. My specimen has been obtained. They have been called for repeated occasions. Come, my lord, cooperate with the investigation. That was the order while giving interim protection. They are not coming. They are not producing the documents. Yes, they are standing in the character of an accused. They cannot be forced under, my lord, with regard to production of document, with regard to this. But they have to come. But because these documents are submitted to PHE, these documents are available. They have to give specimen writings. Thereafter, admitted writings will be taken of them. Admitted writings is what? The documents submitted in PHE.
These are all procedures.
Absolutely, my lord. And that has to be followed. And they are not cooperating. And as such, they intend to say that it's a bailable offence, so I will not cooperate.
We are basically concerned with the fact that whether FIR discloses
a criminal case or not. I'll stick to that, my lord. Absolutely.
That is what is needed. Now, as you say, there exist many forged documents.
Yes.
And which are part of investigation.
Yes.
So FIR discloses.
Yes. Absolutely, my lord. And the sections of law can be added and modified anytime. I'll come to that, my lord. Another argument was with regard to that particular authority by lodging FIR. Suppose I am a mother, I go and lodge an FIR, my lord. I become the informant. So lodging the FIR immune me from criminal offences, my lord. That happens in Sina Bora's murder case in Mumbai. The mother and the stepfather, my lord, own daughter with regard to first marriage was, my lord, the body has been mutilated and thrown off. Sensational matter has been covered, my lord. So informant cannot be an accused, cannot be an exceptional, my lord. In one of my given circumstances, my lord, for otherwise, my lord, in a given CBI matter in the trial, my lord, it was a trap case under section 7 of the PC Act. I was conducting the trial. And while cross-examining, my lord, it has been lengthy one. The witness has been tutored to that extent as it happens in criminal cases. Tutored comes, the reality comes in the cross-examination. One day I have cross-examined certain relevant question, answer been recorded. Now thereafter case was adjourned and another date comes in. After certain questions, he forgot the answer what he has given. Now next question, same questions been put again. Sun rises from which side? East? He said yes, east. Now next sun rises from where? West. Now whether it amounts to perjury or not. The court said yes. This is perjury. On the same breath you are saying east and west. Then I put in question, which is right, east or west? Then he said, previously I said falsely, now I am saying the truth. Admissions. And that informant, my client was, my lord, one Mr. Advani. He got acquitted. And now malicious prosecution with regard to 340 has been, my lord, initiated by, my lord, the CBI Special Judge Court. And he gone for quashing, my lord. And the matter has been pending in the High Court. So that's been the sum and substance, and these are the provisions that for that purpose it has been made, my lord. And with regard to, my lord, what document that has harmed his reputation? Absolutely, my lord. A document, you have said that I have made it with regard to this, and these are forged documents, these are not my signature, and this has been on the record. It's a part of the investigation of this case, not that particular case. Because of the fact this document has been furnished to me by under the RTI at Meghalaya. And on the very basis, as I am alarmed with regard to the consequence of that, that forced document with my signature has been put in and siphon of government exchequer, public money to the tune of lakhs of rupees. What they are saying and submitting, my lord, are contrary to records. And with regard to director false documents, Sudeep Goyal, my lord, I have already submitted, my lord. And with regard to the law, I'll try to satisfy this honorable court. It is judgment to the 2010 Anju Chaudhary. I am not bothering this honorable court with regard to T.T. Anthony's case, my lord. It's altogether a different footing, my lord. But T.T. Anthony has been interpreted by my learned senior colleague is not the correct proposition of law. This is with regard to second FIR with regard to the same cause of action. So here is not a same FIR cause of action. Here is a different allegation.
See, basically the impression which was created before the court by the petitioners was that this FIR is a kind of statement of defense to what allegation
that is not
has been
incorrect.
made. Now, your submission is something else.
Yes.
Say that
Beautifully distinguished, my lord. This has been a judgment of our Chief Justice in Guwahati, Madan Mohan Lukur Sahab and Swetendra Kumar. Relevant para, my lord, 28, 29 and 41 onwards. Yes. 2013, 6 SCC 384. 28 paragraph. May I read it, my lord? As information report, number so-and-so lost by Hazrat, son of so-and-so, related to a burning of a shop prior to holding of a meeting. He categorically stated he had not known the person or names of the perpetrators who attacked the shop where he was working. This incident occurred at 6 p.m. as per records, while the meeting itself as per respondent number 2 was held at 8 p.m. Though on the same day, his report clearly stated when he was going back to his house at 8:30 p.m., he stopped at the place where the meeting was being held. The affair registered by the Hazrat was against unknown person and related to a particular event and commission of a particular crime. There was no question of any provocation, conspiracy or attempt by the persons premeditatedly committed the offences which they committed as per FIR. It was an offence committed at random by some unknown persons. The registration of such affair was neither intended to be or nor was it in fact in relation to a matter of larger investigation or commission of offences as alleged by respondent number 2. Even the offences which are stated to have been committed and for which 2 FIR were registered in these respective cases were different and distinct. In the complaint filed by Parvez so-and-so, which was registered as FIR, names of the persons were mentioned and a general investigation was called for, while so-and-so registered by Hazrat was against unknown persons for damage of property, which was for a specific offence without any other complaint or allegation of any communal instigation or riot. In other words, these are the 2 different affairs relatable to 2 different occurrences. Investigation of one was in no way dependent upon, this is very dependent upon the other, and they are neither interlinked nor interdependent. They also lost by different person in relation to occurrence which are alleged to have been occurred at different point of time against different people and for different offences. Requirement of proof in both cases were completely distinct and different. Thus, there was no similarity and the taste of similarity would not be satisfied in the present case. Thus, we have no hesitation in coming to the conclusion that lodging of the subsequent FIR was not a second FIR for the same occurrence so-and-so, and thus could be treated as the FIR first information for all purposes, including investigating in terms of the provision of the code. It was not in the form of a statement under 162. And it goes on, my lord, 29 and then 41 also, my lord. This is with regard to Amar case 156.3, it was forwarded to the police. And this is again, my lord, a case wherein invoking 156.3, it was sent to the court. 156.3 power has been discussed, my lord, here. And here, my lord, I am not reading line by line, my lord. The 2 different FIRs there, and they come in for it as a second FIR. Distinct offences. Many things can happen, my lord. I went to a place of occurrence. I see A committed murder of B, and subsequently coming in A committing robbery or someone. There can be two affairs with regard to this. This affair at Meghalaya, my lord, is regard to the forgery with regard to that has been committed by the informant.
It's a totally different.
Different, my lord. Absolutely, there is no relatable with this, and I have demonstrated before this honorable court, and it will be available in the case diary. And that at the threshold, this criminal petition is liable to be dismissed. Why? Because of suppressions. And Justice Gyani was there, my lord, at the inception of our career when we joined this, my lord, profession, my lord. It's a very noble profession. I always think, my lord, and Jotin Chaudhary sir, James Chaudhary sir always taught us, when you come to the court, you come with clean hands. You expect an order. If you are not entitled to an order, court will give you an order. But when you come to a court by suppressing of material facts with half-truth, court will never entertain it. And Honorable Justice Gyani's judgment has been there, that when he got an interim order also, by way of fraud, it's no order in the eye of law. And that's what it is. Niharika, my lord, Niharika, I am relying on it, sir. Niharika judgment, yes. Yes, 20 years. Did it? 8 sir, did it? That has been the after, my lord, this, yes. Did you quote? Paragraph 29. That is the parameters wherein this honorable court will appreciate, my lord. This is not a trial court, my lord. And this court will never enter into that with regard to allegation and counter allegations, my lord. 80. Para 80, my lord, under which, my lord, invoking this 482 jurisdiction, my lord, or under 226, this court will interfere. One judgment comes in, my lord, wherein they are relying it, that the Calcutta High Court, Calcutta registered case was set aside by the Calcutta High Court on the ground that is a civil nature. Went to the Supreme Court, say the initial stage of investigation, so we don't interfere. Same principle is applicable here. So that has been a sword with double edge, my lord, and that entitles that their case has to be dismissed. Now, paragraph 80, my lord, these are the things, 7 grounds were there in Vajanlal, my lord. Now, it has been a law, we are following it, my lord. Police has the statutory right and duty under the relevant provisions of the Code of Criminal Procedure contained in chapter so-and-so of the Code to investigate into a cognizable offence. Code would not thwart any investigation in the cognizable offence. It is only cases where no cognizable offence or offences of any kind is disclosed in the first information report, and that the court will not permit an investigation to go on. Only that. The power of quashing should be exercised so-and-so with circumspection. It has been observed in the rarest of the rare cases, my lord, that in case of death sentence, my lord, rarest of the rare, same principle of law, my lord. While examining an affair, complaint, quashing of which is sought, the court cannot embark upon an inquiry as to reliability or genuineness or otherwise the allegation made in the affair and the complaint. Absolutely, my lord. The affair is not encyclopedia with regard to the 161 statement, the document that has been relied on, the investigation part is to be looked into, my lord. And same principle, my lord, I am not wasting the valuable time of the court, my lord. These are the general principles. And even one ground they are not covered with it, either in Bhajanlal or otherwise. And they may say, my lord, that one ground, that is that any criminal action or initiation of criminal with vendetta, that ground they may take in. My lord, prima facie, my lord, with regard to that ground, they have to explain that why this discrimination with regard to this, why this document that has been found here, the signatures with regard to prima facie shows these are not the signature of that particular person.
Just show your FIR whether you have reference of all those documents which you have.
Yes, it's been annexed, my lord. I take your lordship, my lord.
Yes,
FIR? Yes.
Just show that where you have referred.
It will be in the case diary also, my lord. But anyway, I'll take your lordship to their petition itself, my lord. Yes.
Your FIR, yes?
Yes. Every document has been annexed, my lord.
FIR you will find at page 18 of the.
Yes.
No, those documents which you
Yes. Annexure B, A, B, C, everything, my lord. E.
Where it is?
My lord, in paragraph 2, my lord, paragraph 2, my lord, will kindly see. With regard to this is the amount with regard to that particular case and the litigation been pending, he have described. That doesn't mean it is my defense. What I am stating in paragraph 4, my lord, will kindly see. Supporting document given by last line, my lord. Jindal along with FIR many documents prima facie contrary in nature and forced by Jindal for the benefit of so and so, so and so. And paragraph 4, second line. Annexure B to be referred. All these documents which I have got through RTI. And these are department documents. And paragraph 5 also, my lord, will kindly see.
These are the documents which you have referred just now?
Absolutely, my lord. That we have annexed in our reply, my lord. And they have, my lord, annexed certain documents, my lord, for which I am praying for another inquiry by this court, invoking its power under 340 for annexing false documents. I'll come to the definition part, my lord.
That is not required. We have not gone to that stage. Why,
yes,
why to that?
My lord, what I am on, in regard to the definition.
Why come to 340 now?
Thinking, my lord. Manual. 463, my lord. Whoever makes any false document. So I make a false document to be the Prime Minister. Whether I am the Prime Minister or not. If I am not, it's a false document. It is not forgery, but it's a false document. There is a distinction between the two. Here is a case wherein they have annexed false document. It is not a matter of forgery. So far with regard to submission of document, these are false documents. Where is my client's signature appears, where it is not.
Which are forged and which are false?
Yes, these are two different things.
No, which in
they
your
have annexed their false document because these are not available in this.
So all documents are false documents?
Yes.
The documents which you have referred to herein?
My lord, the document I have referred to and they have annexed in their criminal petitions are false documents.
False document.
These are not false documents. Because this document is not available in this, my lord, in the department.
But then somewhere you said your signature has been...
Yes.
So that
document, my lord, we have annexed in our affidavit in opposition.
Which are false document and which are false?
Yes, I'll take your lordship to do directly to that. My lord, here, in this particular petition, my lord will kindly come to. A minute. Yes. I have marked it, my lord. Page 13, my lord.
Page 13 of?
Their criminal petition, page 63. Internal page, it will be 63. Right? Page 63 is a false document. Then?
No, 63.
Yes.
Earlier you have not referred. You started from 64 earlier.
62, 63. 64 is again false document. 86 is again a false document.
If you go slow, please.
Yes, madam. I'm sorry.
No, 63 you say this is a...
False document not available there.
False document.
Yes. 64 also same, my lord. False document. Again 82, my lord.
What about 67?
67, my lord. 67. You to 67, 9, 67A. This is 67. This is false, right? False. Forced or false? False document. This is not false.
No, 67 here.
67, my lord, they have... yes, next page, my lord. It ought to have been like this, my lord. They have flip-flop it. 67, then 67A comes.
67, you are saying this is a...
False document.
False document.
And 86. 86 is false document and 92 is a false document. These are the false document. And so far false document is concerned, my lord, wherein my client's signature are forced and they have submitted bills and siphon of government's money, my lord.
Yes.
That I come to, my lord. Affidavit in opposition, page Page 30, my lord. Yes.
Page 30, 33,
Yes.
51 and 15.
Yes. These are available in the
These are all forged documents.
force.
What about page 15 also?
15 also force, my lord. 15 is not force, but it's a false document. On that day, he was not a director. And with regard to that provision, my lord, 360, my lord has gone in many a times, my lord. Even then, my lord, can you accommodate me to that extent of reading the provisions, my lord? 363, my lord. Yes. Wait. 464. Sorry, 464. 463 is the definition, my lord. 463, I am reading it, my lord. 2, my lord, you will kindly see 2 has been amended on 17/10/2000. So now electronic record also, my lord, kindly see in the Companies Act, my lord, the returns has to be filed. Auditor's report is to be updated in the register of companies. And if this requires, my lord, something has been updated in the registry with regard to Companies Act, and these are digital signatures, and the contents of it is false. Suppose a directory of a company, my lord, private limited company, at least minimum is 2 director, maximum is 3 director. Suppose 2 director connivance with each other, and thereafter makes a forged document. And they say that quorum is there with regard to 2 documents. He has tendered his resignation, and we have accepted quorum, and we upload it in the register of companies that he has resigned from the company. Whereas that particular resolutions, quorum, and all such things are to be kept in the company head office itself, retained. Now, the moment it is updated and a criminal case has been lodged, what this criminal will do will destroy that particular quorum and everything. So, no document force, so you cannot prove forgery. That is wrong. You upload this, that is again false, unless you can prove the contrary, my lord. And that is with regard to 463 after amendment on 17/10/2000. If your lordship appreciates section 3 Evidence Act, it includes electronic records. And how the mode is to be proved, my lord? For that purpose, 22A has been added, my lord. And 22A, previously it was, my lord, that oral testimony as to a content of a document is inadmissible unless secondary evidence is adduced. Now, after 17/10/2000, the language has been changed and another section has been added. Oral testimony as the content of an electronic record is inadmissible unless and until secondary evidence is given. And the mode of proving is 65A, 65B. And so that amendment comes in, my lord, in 463. Whoever makes any false document or false electronic record or part of a document or electronic record will intend to cause damage or injury to the public or to any person, or to support any claim or title, or to cause any person or part of the property, or to enter into any express or implied contract, or with intent to commit fraud, or that the fraud may be commits forgery, making of a false document, my lord. 2, again amendment, my lord. A person is said to make a false document or a false electronic record who dishonestly or fraudulently makes, signs or executes a document.
So, is it very relevant now? You said that...
Yes, my lord has understood that. My lord, I will not waste the relevant time.
My lord, I'll request my senior to confine to his FIR, my lord. Going from north to south to east to west, my lord, will not serve any purpose. He has to point out what is there, what are the allegations in the FIR, and whether those are the documents he is referring to. He is referring to all kind of documents which are not even mentioned in the FIR, my lord.
That is precisely was a question.
My lord, the law says that FIR on the face of it, my lord, should make out a case. Lordship has seen the FIR, what case is made out in the FIR, my lord. In the FIR, the reference is only to the letter of 25/2021, my lord, of Ramesh Bansal. And what reputation to his reputation has been caused in that letter, my lordship has seen that.
May I reply, my lord? May I reply to it, my lord? I have not concluded my argument, my lord. Let me conclude my argument. And
yes, Dr. Mojika, please.
Thanks to him to pointing out with regard to confinement with my argument to the FIR, my lord. I am repeatedly saying, my lord, the FIR contains documents. Why you have not come with the documents?
Anyway, sir, forget about the documents. I'm just saying whether your FIR is a reference of those documents.
Yes,
Which you
I have pointed out. A, B, C, D, E. Where are the annexes? That will be in the FIR, my lord, with the FIR.
What is annexure A to the FIR? What is annexure B to the FIR? What is annexure C to the FIR? Annexure A is the contract signed between.
No, and letter of authorization, he was arrested, he made a confessional statement that he is forged. Page 72.
Okay, just let him.
Yes.
We'll just come. Welcome.
It's true. On the face of the whether case has been made out. Isn't it true? I take it in another way. That these are the false documents which I am suggesting before this honorable court, placing it before the honorable court with affidavit, with regard to, my lord, this document been taken, submitted to the authorities, siphon of government money. There may not be a specific allegations.
Documents, whether these documents are seized by the police.
Yes!
You have a seizure list.
My lord, the London PP will say.
In connection with this case.
Absolutely. That's why I am submitting before this honorable court. As FIR, my lord, on the face value, my lord, a person not being acquainted with the law, an FIR has been lost, a person by a person, at the face value, my lord, with regard to this, will not be interfered with at the stage of investigation, at initial stage of investigation, when the materials collected during investigation shows that on the basis of the FIR, materials been collected and investigation is proceeding in the right direction, and these are the persons who are not cooperating with it. This is not the mandate of law, to quash an FIR at the initial stage, wherein prima facie all these documents been part of the FIR. Why they have not annexed these documents, my lord? They have to answer that. And these are the documents are subject matter of, my lord, investigation. Subsequent information has been provided to the IO, my lord. This has been part of the investigation. And quashing of the, not the FIR. My lord, here the quashing of the FIR and subsequently all action been taken. What is the consequence of it? I have been deprived of my grievances. A person siphon of government's exchequer money at the, my lord, by submitting false document.
My lord, this submission, my lord, I'll just interrupt because a falsity is being presented. It is our pipe, my lord. Jindal India Limited has entered into contract with the government of Meghalaya, and we are supposed to get money. Who is he, my lord? He is simply a commission agent, my lord. And how is agreed that we are getting our money, my lord, from government of
on the basis of false document? My signature.
Who is he, my lord, to object to that, my lord? And is that a subject matter? That is not even a subject matter of the entire thing, my lord. Lordship, if my friend only confines to the FIR, if he is not happy, he can file a fresh FIR. That is altogether different thing. But whether this FIR can sustain, my lord, that is a question for Lordship. If he has some more material, he can file a fresh FIR. That he can do, my lord.
No. Why I file a fresh FIR? But the criminal jurisprudence at a nutshell is this. It is the investigating officer who receives an FIR, whether he will see whether prima facie case has been made or not, whether if materials on record otherwise makes out a criminal offence, even considering a criminal offence, even the FIR doesn't make out a case, he'll register a case and start the investigation. Here are serious allegations. Now they want to jump the guns. Here is a case wherein, my lord, the department authorities' statement were recorded, my lord, by the investigating officer. And they say these are false documents.
The second falsity.
On the basis of which they have taken siphon of government money. This is the allegation.
Who has siphoned of whose money? That is the.
My lord, whose money? It is their money.
They have siphoned of 16 crore rupees of the petitioner company, my lord.
My lord, this is a
counter allegation will not happen.
And this is ridiculous.
It is useless.
Only one point, my lord. Lordship kindly turns to page 20 of the criminal petition, my lord.
And you just allow him to finish. Let him finish.
My lord, because one incorrect statement is repeated, my lord. That's why normally I don't stand in the middle, my lord. It was submitted, my lord, that respondent number 2 is a what citizen of Meghalaya, is a very honorable citizen of Meghalaya, my lord. My lord, kindly see his address, his own handwriting, my lord.
Yes,
he's from Calcutta, my lord.
Let it be. My lord, here, my lord.
But it is
here,
the case is projected, my lord, as he was a very honorable citizen of
Honorable citizen of Calcutta, he is residing here, he is contesting here.
Statement was made that he is a citizen of Meghalaya.
It's okay. It is useless. If you fight among
These are
yourself, then
the things, my
court
lord.
room may not be a proper place to do.
Incorrect statement, my lord. That's only I'm only pointing out that the incorrect statement.
Okay.
I'm not arguing on law, but only what incorrect facts are being placed. I'm only.
Dr. Majiga, apart from that, the two things. The one thing is that the submission is that this RTI information was obtained here in Meghalaya, and all those documents lying here, this has been used for the purpose of effective
That
transaction.
Mr. Mishra will reply on. I'm not replying, my lord.
Now
I'm only pointing out these two facts, my lord, only, my lord, that incorrect statement is made. Just to create separate evidence.
Anyway, this will not have a bearing as far as the court is concerned.
It's a false document.
Is a citizen of Meghalaya, is not a citizen of Meghalaya.
I'm a citizen of India. Do you have any
Statement
doubt?
is made. He is the honorable citizen of Meghalaya, my lord.
My lord, he is staying out here, he has been preparing out here, honorable citizen of Meghalaya. So, it is Meghalaya is not out of India, are you saying that?
My lord, the impression is so to gain
This kind of argument, my lord.
Gain sympathy from this honorable court. It was submitted that he is an honorable citizen of Meghalaya.
I am arguing on marriage.
Correct, my lord. That's what
I am arguing on marriage. And, my lord, here, my case is very simple, sir. I'm summing up my argument. This is my case. That I have lodged an affair after the RTI reply. When my signature appears in this document, on the basis of his bill payment has been made. These are 4 signatures. Now, the matter is under investigation. I have given my specimen writings. This matter with regard to this is not the subject matter of West Bengal. These are separate distinct offences committed at Meghalaya.
That is what submission is precisely. You are saying that right from the beginning.
Yes. So,
saying that your information relates to separate incident.
Absolutely.
It is not covered by.
Yes. There is that they have supplied pipe, it has not reached the destiny, this accused person has siphoned of the materials. This is their case. This is not my case. My case is that they have taken money from the department by forging my signature and taken government money, and payment has been made from Meghalaya. Cause of action arises, my lord. When, my lord, forgery has been committed here, the police at Meghalaya has all the power to, my lord, investigate, and they are investigating, my lord. What material has been collected during investigation, my lord, will be, my lord, eye-opener. In their quashing petition, my lord, last limb of my argument, my lord, in paragraph 8 they have received, they have stated, my lord, they may be very, my lord, powerful persons, my lord. They may be, my lord, have high stakes in the society, but they are not absolved from the law. Law is equal for all. And what they make a statement in paragraph 8, that the petitioner has received a notice under 91 of the code of so-and-so in connection with the instant case. Moreover, so-and-so, a director of so-and-so also wrote a notice under 41A of so-and-so. So the same Ramesh has received earlier notice directing him to appear before the investigating officer. They did not appear. My lord, it may be a case of 506, criminal intimidation. But the part of the investigation is, my lord, have to cooperate, my lord. Nobody is above law. And for that purpose, no coercive actions, this court has already protected them. Even that they are not cooperating. Why they are not cooperating? Because the cat will be out of the mouse. Because they would be confronted with this document that produced me that Bansal was a director of that particular company. They cannot produce. They have to produce this document that this is a bill on the basis of payment has been made. Who has signed this document? They have no explanation, and for that purpose, under the guise of invoking 482, my lord, inherent power for the criminal acts, they are before this honorable court.
Now, those documents,
yes,
you were saying,
yes,
that they did not enclose with the FIR.
Yes.
Have you filed those documents before the court?
Yes.
In the same form?
In the RTI, my lord, affidavit in opposition.
But not in the same format as you enclose with your FIR.
No, not required. That has to be produced. Now here, by FIR.
See, whether it is required or not required, that is not. The query is that you have not basically enclosed it in that form.
Format means?
It's like here you have referred to annexure A, B, C in your...
Not that format, my lord. For the purpose of understanding and for the purpose.
Purpose of asking is that
Yes.
it would have been easier for the court.
Yes, to understand that.
If it is your allegation
Yes.
that these are vital documents,
Yes.
and they have intentionally suppressed it,
Yes.
so whether those documents
Yes.
you have brought it into records or not,
Yes.
that is what the court's query. And then you say you have brought it, but they're not in the same form
Yes.
which you have.
Yes. Whatever I have got it from the RTI reply, I have annexed it, and these are the signatures that appears, my lord, and which has been subject matter of investigation. I have provided my specimen writings, my lord. And the investigating officer is repeatedly noticed.
Shula, you are having this copy of the FIR and everything, the original copy and all, especially this annexures, AV and all. No, this will be, see, like this.
Very important.
We do not know this, what are the documents and all. So like we have to now think whether those documents referred to in by the.
It appears, Your Lordship, during the course of the investigation, certain documents are seized by the police.
Please come here. No, I have concluded.
Right. Like documents which is at page 67 repeatedly, 86, 87, 91, 92, these appear to have been false or forged documents, Your Lordship.
No, those were seized by the police.
All this seized, Your Lordship. In fact, I have made a comparison which are the documents which were produced, genuinely seized from the PHE department, and which one which are produced by them enclosed in the petition herein. I have made that. Lordship, the investigation is at the initial stage, Your Lordship. It is, in my humble and respectful submission, Your Lordship, it is still an unborn child, Your Lordship, this case. That's why, Your Lordship, after keeping all this document, we have issued notice to them, Your Lordship. We want to know the source of this document. Certain witness, Your Lordship, that I forgot his name, what Mr. Dhadania, Your Lordship, he also has denied to have made those documents. Rather, he has stated during the course of the investigation that his signature have been forged. And that letter of Ramesh Bhansal, Your Lordship, that is a forged document, Your Lordship. Kindly see, Your Lordship, on they have filed this quashing petition, Your Lordship, basing those documents which are either forged or not genuine. Can you see, Your Lordship? Can you see the conduct of the petitioner, Your Lordship? Police.
That is what the RTI says.
Yes, yes, Your Lordship. Even I have made a comparison, a small note, Your Lordship.
Can RTI information be conclusive proof in law?
No, Your Lordship. This has been seized by the police, and on comparison, it appears, Your Lordship, that these documents which have been annexed, Your Lordship, are either forged or not genuine at all. So these are a matter of investigation, Your Lordship. It's being investigated, Your Lordship. That's why we have issued notice to them, Your Lordship. They refuse to cooperate. They refuse to, Section 91 CRPC also had been issued to them, Your Lordship. They are not cooperating with us, Your Lordship. Rather, they are telling the police that we have filed a quashing petition in the Honorable High Court.
Interim order say that they undertook to.
Yes, that's why I have filed an application, Your Lordship. Otherwise, I would not have done that, Your Lordship. I know this is a billable section, Your Lordship. Otherwise, we would not have done that, Your Lordship. Considering the fact that you made an undertaking before the Honorable Court and you breached that undertaking.
My Lord, I believe that this aspect.
We'll come to you.
My Lord, only because this was agreed that the matter is being heard finally. If Mr. Chula is arguing on that, my Lord, then it should have been told at the beginning. Mr. could have replied on that, my lord, because we also filed the reply
That's
to
all
that.
right. That's all right. These are besides the may not be a main issue, but then see.
Because to their misapplication for modification of the interim order, we have already filed a reply also. If Mr. Chula is arguing on that, we will reply to that. But this was agreed that the matter is being heard finally. So why Mr. Chula is again raising that issue, I fail to understand.
Then which way will answer that thing, non-inclusion of documents with the FIR in your petition?
My lord, here what happened, my lord, when we applied the FIR from the court at Joy, certified copy, my lord, this is what has been given to us, my lord.
No, but then it referred to, if you go through that.
It refers to an excess, my lord, but we do not know.
You could have understood that thing, you could have.
Because we do not know, my lord, when we apply to registry, my lord, we cannot check whether there is, we apply for FIR, they are supposed to give the complete FIR, if at all it is available on record, my lord.
And then can it be answered? If you approach the court, you should come with a complete set of information.
They can produce a case diary, it is there, my lord, it must be there within us.
But the thing is that this will have to then, in such a case, the court will have to again compare all the documents and all those things.
In fact, I have made a comparison, Your Lordship. Few documents I have made a comparison, Your Lordship.
Even it contains the documents which have.
Yes, Your Lordship, which they have been closed and the one which were seized by the police.
Now, what about documents which are
Document annexed to the FIR, that is the question.
FIR. Can you produce the FIR?
Lordship, let me case diary.
You are not getting
because I have just requested the police to give me the gist, and then
Is that
those documents alleged to have been forged and not genuine. That's why that has been. We can have on some other day, Lordship, I'll produce whatever.
The thing is that argument has been made. The thing is that then again, you have to refreshing process as to see, like this court has very short memory, you see.
Same thing with me, Your Lordship.
Mr. Chula can get it, it's a joy only, my lord. You can produce it day after tomorrow.
Day after tomorrow, we can have it day after tomorrow.
Previously, second or third item, my lord, remember that case, division bench, everything is in memory, my lord.
That is something you see like that.
Chief is there, my lord, it's very, my lord.
We can have it day after tomorrow, Your Lordship. I'll have the case diary.
I think it would be, at least if you produce the CD, at least for perusal of the FIR, that would be, because we are not having complete set of FIR.
Yes.
Whatever documents on records are there.
Whether CD will have complete FIR, I don't know, my lord.
Those annexures,
it should.
If they do not have, then we will make a note.
But from court record, because we can only apply from court, my lord. We apply from court and this is what has been given to us, my lord.
See, this FIR specifically speaks about certain annexures, and these are missing. So this is what
we made our effort, my lord, but we could not access the annexures.
What we do, my lord, in these cases, why don't we make a statement? That there are annexures that have not been supplied. What is the statement? They are projecting FIR itself is in that manner. That is wrong.
Yes, you are correct. Normally, it should have been.
Absolutely.
Mr. Chula can produce that one after tomorrow.
They can, but
then they have closed certain documents which are not really.
And what are the things you prepared? You said, Mr. Shula, you said just now?
Lordship, I have made the statement of the witnesses and the statement of the accused, then the quantity of consignment received by the PHE department, then the payment made by the PHE to the petitioner, and then the false document.
All those things court is not much interested. We are just trying to, find out whether FIR at all makes any allegation, which is something different from the.
Because going by the version made in the FIR, Your Lordship, in my humble and respectful submission, yes, it discloses a prima facie case, Your Lordship, because there is a statement made in the FIR regarding forged document, and when the investigation comments, Your Lordship, it is that we got these documents, Your Lordship.
Let him produce the.
Lordship.
Day after tomorrow.
Day after tomorrow, then, Your Lordship. You come physically. Come physically. 13. Oh, no, today is what date? 9. Day after tomorrow on 11. 11. 12. Yes. We can have it on 12, Your Lordship.
I have no problem. See, you see, it's up to you.
12th will again have difficulty because Mr. Mishra has requested for 11. 11. Day after tomorrow. Day after tomorrow.
And nowadays, my lord, online is there.
Yes, yes, online is there.
I'm thankful to the court for giving me a patient here.
No, see, this is basically a privilege to have you all here. You come to know many things.
That's why I'm requesting him, Your Lordship. I'm requesting him, please be here physically. I'm requesting him, please be here physically. Even I could have requested Senior Counsel D.K. Mishra also, but still he has left, so I could not get a chance.
He expresses inability to remain there.
Otherwise, I would have requested him.
You, right? You'll record the names. Okay. Then you'll just say, Mr. Andy Shulai, Learned AG, will produce the case diary.
Case diary, Your Lordship.
Is this matter again? Huh?
11, Your Lordship.
11. 11.
Lordship, yes.
11th also? After.
Apply, Your Lordship.
Apply.
$14.
Yes.
I'm appealing for a private respondent.
Yes.
Otherwise, the issue is very small. But considering I don't know, my lord has a very long day in the court. It's a very small issue otherwise. If your lordship permit.
So what is that issue? Just you tell us.
Issue is, my lord, we have filed. I am for the respondent, your lordship. Petitioner has filed for quashing. Now, in the meantime, my lord, there was a compromise, and we have filed an affidavit annexing that compromise date. Now, the only question on the last occasion, lordship, is what is the position of law? Only one of the offences is non-compoundable. Now, law is very clear, my lord. We have brought that decision, Gyan said. Paragraph 57. It says that, my lord, even the non-compoundable food has the power to quash it. To quash it.
Yes,
provided there is no moral depravity and other thing, your lord. So here is basically the issue, my lord, the dispute was something civil in nature. It's regarding, my lord, some tampering with some water source and other thing, your lordship. That FIR is there, we will read out the FIR, and then the compromise deed, and that paragraph 57, that issue.
Whether this thing falls under the category of that Gyanshing.
Exactly, your lordship. We'll try to convince. That
This
point.
is a case of destruction of public property.
Then see,
Let them argue, Your Lordship.
see, Mr. Sen, one thing. Now, because you see, like, we may not have much time. That is what, precisely, you see, like this issue, basically, if it is covered by that decision, okay, we can give a try to.
That is why, my lord, considering
But
the
then
policy,
if-
yes, if your lordship can take
can
it
have
up
answer
tomorrow,
for a day.
if your lordship can take it, accommodate us tomorrow.
Tomorrow, yeah.
Today I understand, my lord, has a
Tomorrow,
long,
again,
very
we do
long
not
day.
know what will crop up the main thing. See, this is it's a problem.
Tomorrow, according to your convenience of your lordships.
Then this is only a new case, only very fresh case.
Very fresh case.
That is, considering the nature of the issue and the matter has been compromised.
See, this court also would definitely like to dispose of matters if it can be disposed of. But then the thing is that if it takes time, and as Mr. Shulai has submitted, that involves destruction of public property.
No, this is better.
This is
a lordship.
That is the main hurdle.
No, we'll convince your lordships.
But in this case, my lord, is a Kaban also by the Rajar Bench Supreme Court, my lord. Rajar Bench Supreme Court has.
What is that decision? What is that? What to?
Regarding that civil matter, my lord.
How can destruction of a public property falls within the civil dispute? I feel understand.
May I suggest one thing, your lordship? These are all matter of hearing, your lordship. Once your lordship heard the petitioner, hear me and hear the state, your lordship. Then only lordship comes whether it is a civil matter, whether it is called for interference and not. No, today, your lordship.
If you have a compromise, why you come under 482? You have the options. Go to trial court. You can have seek withdrawal from prosecution.
No. One of the offences is non-compoundable.
That is why withdrawal from prosecution. I did not say compounded.
Lordship. No, but here the question is what the law say. Even in the matter of offences are non-compoundable, 482 can be exercised. Now, only thing your Lordship will see whether this can be exercised in the facts and situation of this case. So, this is a matter of submission. What I am praying, your Lordships, today it may not be possible. Lordship has a long day. It will be taken up tomorrow.
We'll take it next week. We'll try to have it next week. The question is not a long day short day. The problem is that the passing order there.
Yeah, I understand.
For a man like me who is not very equipped in those, like modern technology, it is more difficult.
Any day convenient next week.
We'll have it next week, sir.
Okay, sir. Your Lordship.
Then it will be fixed, then your Lordship. So that can have it on 18, your Lordship. 18.
Okay, list on 18th.
Whether it's available or not today.
18th, all right? It will be all right.
Yes, okay, madam.
That will have it on 18.
This is my 18th as pressed by parties, both parties.
All right.
Second call, item number 1.
May it please your Lordship. Lordship, this matter, I was told that appearance has been made. So
Yes.
we can fix this matter, your Lordship, for a final hearing.
There's no urgency, so that since the trial court have also given a long date, next date is December 19th. So we can
have it.
Yes, we
after
can
2-3
have
weeks.
a,
After 2-3 weeks, we can have it.
after 3 weeks, then your Lordship.
Mr. T0.
TL, your Lordship.
T0. Enters appearance on behalf of the respondent number.
Sole respondent only, your Lordship.
Enters the sole respondent. Stop. The parties submit that the matter is ready for hearing. List for hearing after 3 weeks.
3 weeks. That's fine.
Nothing more.
Lordship.